Simpson kills those two people so hard, they stop making the Ford Bronco.
Hey, good morning, good afternoon, good evening, good night. How are we doing wherever you are? It is 10:01 p.m. here in beautiful, dark, and almost wintry Busan, South Korea. Gorgeous day today. Going to be a nice chilly evening tonight. I hope you're doing all well. Hope you're all doing well. We're going to settle in here and we're going to be watching some OJ Simpson tonight. That's what we do on Thursdays. Thursday is OJ Simpson Day, and we're continuing the seemingly never-ending cross-examination of Detective Mark Fuhrman. But actually, we should be finishing either today or early next week. We're coming close to the end of the Mark Fuhrman cross-examination. So what happens at the end of the Mark Fuhrman cross-examination, you ask? Well, I'm glad you asked, because I'll tell you. We skip ahead a few months in the trial to where the defense calls witnesses to rebut Mark Fuhrman's testimony. Namely, a screenwriter who is going to testify that she heard him using the N-bomb several times, and Kathleen Bell, the one that earlier reported that she heard him using the N-word at a Marine recruiting station. They'll be called as witnesses. Then there'll be some fireworks and some shenanigans as we wrap up the Mark Fuhrman episode of this. Then we'll move on to Dennis Fung, the criminologist, who was just eviscerated on cross-examination by Barry Scheck for 8.5 days. So that's where we're going with this trial. But hopefully we will be very, very close to finishing the Mark Fuhrman testimony today if we don't finish it. So the end is in sight for Mr. Fuhrman. Good evening to all of the mods that are here helping out. I saw that Flux was oversharing a little bit before we started, but we're glad to have all of you mods here. We're glad to have all of you here in the chat because the Vice Squad is the best chat on the internet, hands down, full stop, no question about it, completely an inarguable fact. And for those of you that are just watching us, you have us on the background while you're going about your business, while you're going about your work. Hey, thank you so much for having us here, and I hope you'll come back and give us a like a little bit later. So this is what we do, as I said, on Thursdays. Tomorrow, we're going to be hitting day 2 of the Courtney Clenny bond hearing. Yesterday, as you saw, the court feed was a horrible video and nearly as horrible audio, or I guess you could even flip that. They were both equally horrible. Day 2 is a little bit better. They seem to have got their stuff together for day 2. So that's what we're going to be doing tomorrow, day 2 of the Courtney Clenny bond hearing. Next Monday, we'll be doing our usual Monday Maritime Monday usual disastery thing, but we're going to try to find something that's not so Debbie Downer as the last couple of weeks have been. Next Tuesday, we're going to be looking at the Idaho murders, the unsolved Idaho murders, and an update on the Taylor Shabusiness, chop up your boyfriend and leave both of his heads in a bucket for his mother to find in the basement. Update on Taylor Shabusiness and the latest on the unsolved University of Idaho murders. Wednesday, we're probably going to be getting into the Colorado shooting, some of the information and stories surrounding that. And then next Thursday will be OJ Simpson Day again. There's our weekend preview. All right, guys, we are here, and we've already got our very, very first super sticker of the day, which is what? Hey, where'd the chat go? No, there's the chat. Got to scroll up for that to see what it was. But thank you, X Homer, for the super sticker. It is a pile of crap. There. I'm so glad I scrolled up for that. Thank you so much, Xcomer. And also, Xcomer gifted 10 Legal Vices memberships. So if you were one of the lucky people to get a subscription from Xcomer there, please give him a shout out. Give him a big thank you for being so generous as to donate and gift 10 Legal Vices memberships. All right. Where are we with Mark Fuhrman right now? You may remember from last week or from the last 2 times we did this, that there's been a little bit of fireworks. We're going to revisit the fireworks between Marcia Clark and F. Lee Bailey a little bit later on remember that F. Lee Bailey said that he talked to one of the witnesses, a Mr. Cordoba, who was at the Marine Recruiting Center when Mark Fuhrman allegedly dropped the N-bombs. And then, was it Dateline did a report where they talked to him and he said, no, I've never talked to this F. Lee Bailey guy. So Marcia Clark stands up and accuses him of lying to the court and being dishonest and doing all of these other shenanigans, to which F. Lee Bailey objects. And then we went into the back into the cross-examination of Mark Fuhrman, where he was just denying knowing anything. He didn't see anything. He only found the most important pieces of evidence, but beyond that, he didn't know anything. Anybody that said he ever used the N-word is an absolute liar. And then when we left it, F. Lee Bailey was calling into question his detective skills because he couldn't remember nothing about nothing. A little bit like the detective in the Courtney Clenny case yesterday, if you saw that disaster. And that's where we're going to pick things up as soon as we dive back in, after thanking John Robert for the $20 super sticker, which is, let me pop on over here. It is a lemon hugging a lime. Aww. Which is kind of appropriate because I wanted a little bit of a cola beverage. So I had my Pepsi Lime, and I put it in a glass and thought, I've got some Pepsi Lime here in the glass. I should probably put some real lime in it. And then as long as we have cola and lime in it, I thought, why not pour a bunch of rum into it? So here we go. Sort of my Cuba Libre, but I guess it's like a Pepsi Libre. We'll see how that goes. And of course, it is in my official Johnny Depp Mega Pint Legal Vices Pimp Cup. And we haven't seen this for a while. So, all right, on that note, got a lot of ground to cover. We're going to go at this for 2 hours. So let's see how far we can get. Again, picking it up, F. Lee Bailey questioning Mark Fuhrman about his seemingly non-existent detective skills. Let's go. Oh, and by the way, guys, tell me how the audio sounds. If there's any problems with the audio, let me know. I tried to undo all of the horrific settings we had to do to make yesterday's stream possible. So let's see if everything's back to normal. Let me know if there's any problems. There are no closed captionings for this part of the hearing, unfortunately. And like I said, just let me know if we need to adjust the volume, and I will decide whether or not to act accordingly.
Were you, Detective Fuhrman, during the course of your stay from 2:10 a.m.
I'll bump it up to 200
until you talked to Ship, let's say around 10, is that correct? 10 o'clock?
I don't recall what time he called.
Mid-morning?
I believe so.
All right. Were you engaged in your profession as a detective of the Los Angeles Police Department?
At the time I talked to Mr. Ship?
No, sir. From 2:10 a.m. when you arrived on the scene until at least mid-morning on the 13th, were you engaged in your profession as a police officer?
Yes, sir.
Were you being paid to carry out the function of a detective during that period?
Yes.
Were you giving that your best effort during that period?
I was being directed.
Notice
Yes.
that pause
You were
that
being
he was
directed.
Yes.
when asked
You weren't
whether
directed
he
to
was.
the Bronco, were you?
Okay, we need to do a little bit of background here for those of you that haven't been following this. Notice how he paused when he said, "Did you give your best effort?" And he kind of paused and said, "Well, I was directed." That's where he made his first mistake of today. Anyway, he's been making mistakes for the last 7 weeks. We've been watching this cross-examination. Okay, what the deal was is he's saying. F. Lee Bailey asked him questions. Why didn't you do this? And he said, well, I don't know. I didn't think about it. I didn't do this. So what he's asking here is because Mark Fuhrman was the one who found the blood evidence on OJ Simpson's white Ford Bronco. He wasn't asked to go down there. He wasn't told to go down there. He wasn't even supposed to be down there. He just kind of wandered away from the other detectives and walked around to the other side of the Bronco and said, "Oh, I found some blood evidence." And he also happened to be talking to Cato Kalin and was walking, or he walked around. No, none of the other detectives, the lead detective on the scene, didn't tell him to go and check back behind the house. Nobody told him to go back there. He didn't tell anybody he was going back there. He just kind of wandered back there all by himself, unbeknownst to any of the other detectives on the scene, and oh, I found a bloody glove hidden under some leaves. And that's what F. Lee Bailey's talking to him about now. When he's asked him, did you do your good job? Did you do your best job? He said, I was directed. And then he starts hitting it. Well, nobody directed you to go to the Bronco, did they? And it takes off from there.
You were being directed?
Yes.
You weren't directed to the Bronco, were you?
Cotton
No.
itch.
You weren't directed to the south border of the Simpson property, were you?
Yes.
By whom?
Mr. Kalin.
Mr. Kalin ordered you to go out and look for where the noise came from.
Cato Kalin, the house guest, the freeloading house guest of the OJ Simpson house, who is not a police officer and not a detective. Now he's saying that he was directed by a beach bum to go behind the house. I guess while we're stopped here, we should clear up these two things. X-Comer sends another super sticker. Another super sticker. Or is that the first super sticker? Robert Lawrence sends a $5 super chat. The Sound of Silence. Thank you so much for that, Robert Lawrence. And Stingy doing the early morning run. New Thanksgiving Thursday theory. Vices is secretly the quartering's dad. We're probably not that far apart in age. Same feature, mannerisms, and boomerisms. Think about it. Not that old. All right, on that note, let's hear him explain why he thinks that a freeloading beach bum can direct him or instruct him to go and look for evidence in a certain place. This is Rich.
You weren't directed to the Bronco, were you?
No.
You weren't directed to the south border of the Simpson property, were you?
Yes.
By whom?
Mr. Kalin.
Mr. Kalin ordered you to go out and look for where the noise came from, detective.
No, he directed me by his statement.
Does he have the power to direct any detective in the Los Angeles Police Department?
No.
Detective Furman.
Direction and the logical thing to do would be one and the same.
They're one and the
That's
same.
good.
Do you
Yes.
want to leave it that Cato Kalin directed you to go out and look for the noise or its source?
By his statement? Absolutely.
Okay. You had no choice but to do that without telling anybody, correct?
I had a choice. That was a logical thing to do.
All right. Well, let's continue.
Ugh.
When
Why would you
you
say
learned
dumb shit
that
like
Mr.
that?
Simpson was in Chicago, did it occur to you that the presence of the limousine might be of some significance?
All right, and the main line of questioning was, did you expect OJ Simpson to be a suspect? Did you know where he was? He's like, no, I had no idea. I didn't expect him to be a suspect. Nobody knew this. We didn't know where he was. He's, well, then he gets on the, well, the limousine is there. Isn't that a good indication of what's going on? And let's follow this through.
I did not give the limousine any thought after that.
Did you give any thought to the possibility that Mr. Simpson was or was not in Brentwood between 9 and midnight?
No.
That never crossed your mind.
Well, it was out of my realm of responsibility at that time.
Well, you claim that you found an instrumentality of murder, what turns out to be, on his property. Did that give you any cause to suspect Mr. Simpson?
Knowing he was in Chicago, I think it would be quite the opposite.
All right. So now you attach some significance, as I understand it, to the Bronco, initially against the possibility that people inside would be injured, correct?
Yes.
You had ascertained by questioning Cato Kalin that only OJ Simpson drove the Bronco, correct?
Yes.
And you had noticed a shovel and some plastic, which you did not then understand, in the back of the Bronco, correct?
Yes, sir.
All right. And you have before cited this set of circumstances as being relevant to the pressing need to go over the fence onto the property, correct?
Yes, sir.
All right. Were they also relevant to the possibility that Mr. Simpson should be looked at as a suspect on the 13th of June?
Not at the time as you are describing these, no.
Okay.
Isn't that the most ridiculous, stupid comment you've ever heard? The ex-husband or the boyfriend is always a primary suspect. And Furman says, oh my gosh, we've got to go over the fence because we see the white Bronco there, and let's go. and they find the shovel and some plastic in the back of the truck. He eventually, all by himself, finds some blood on the truck. Then he finds a bloody glove behind the house, and he sits here and expects the court to believe, in all sincerity, he wants the jury to believe that he did not suspect OJ Simpson at that time. How ridiculous is that? Why do cops need to lie like this? This amount of lying and deception and obfuscating that Mark Fuhrman did is one of the primary reasons why the prosecution's case against OJ Simpson was sunk. And again, for those of you that are coming in new to this, I don't do this to change anybody's mind. I want to show how good, solid lawyering can lead to a jury having reasonable doubt as to who committed a crime. And F. Lee Bailey tearing apart Mark Fuhrman on the stand for days is a prime example of how one of the best legal minds to ever set foot on planet Earth can cross-examine someone and push them into corners to where the jury has no option but to have reasonable doubt as to what happened. Absolutely unnecessary. All he has to do is say, of course we thought OJ Simpson was a suspect. Maybe not the only one, but clearly he was a suspect. It would be foolish to assume otherwise, and that would have shut down this whole line of questioning, would have got the jurors thinking, well, okay, they didn't rush to judgment. They had other people, but of course, as the ex-husband, he's a suspect until he's cleared. But no, the cops have got to go and lie. We saw that with the Courtney Clenny thing yesterday. If you watched that, it started out with being a wishy-washy cop, and then he starts lying and hiding facts and not writing things down and changing stories, and it just looks bad. And if a witness lies about one thing, you are completely within your rights to assume they are lying about everything. In other words, Mark Fuhrman gets caught in one lie, you can throw out everything he said on the witness stand and consider it absolutely useless and tainted. And F. Lee Bailey has trapped him at least 100 times in a lie or obfuscation at this point. It is so unnecessary, and it's so damaging to the prosecution's case. And incidentally, Mark Fuhrman will be coming up in our review of the University of Idaho killings because they happened in Moscow, Idaho, and last I heard, Mark Fuhrman lived just north of there in Coeur d'Alene, Idaho, and he's already shown up on TV commenting on the University of Idaho murders. So we'll be back to him on Tuesday next week.
When you learned that he was the only driver of the suspect of the Bronco, according to Mr. Kalin, were you interested to know whether the Bronco might have left the premises that night during the period during which the murder may have occurred?
That would have been helpful, yes.
It would have been helpful. Oh, no. When
Would have
you
been helpful,
spoke
but he
to
didn't
Ms.
do it.
Lopez to get permission to go back along the borderline and wherever it was you wanted to go on the Salinger's property, did you ask her any questions whatsoever about the Bronco?
No.
Or any questions whatsoever about the doings at the Simpson place the night before?
No.
Okay. Did you then go and make an inquiry or investigation of the terrain to the south side of the Salinger property along
Yes.
the fence?
Yes, sir.
By the way, did you ever identify yourself to Rosa Lopez
Yes, sir.
as Detective Furman?
I remember tracking.
Okay. Did you take any notes when you talked to her
No.
or make any later on of the conversation?
No.
And did you ever say to her that you would
The
have
detective
some
didn't
other
take
officers
notes
get in touch
talking
with
to a witness.
So as far as you were concerned, there was no point in you or anyone else questioning Rosa Lopez.
There was nothing she indicated that should be interviewed for. No.
Well, you never asked her a question. How could she indicate anything?
As far as I'm concerned.
Do you determine without asking questions whether witnesses have information?
No, sir. You misstated. I wouldn't have interviewed her.
You would not have interviewed her.
No.
As a detective, you don't interview witnesses.
It was no longer my case. Detective Lang and Van Etter will dictate what interviews and when.
Did you ever consult with them and say, I'd like this time to ask your direction. Should I talk with this lady next door?
No, Detective Lang was on the Bundy crime scene and Detective Van Etter was writing a search warrant.
This is so bad. This is so horrifically bad. The detective's not talking to neighbors because that's not his job. He didn't think she would have anything to offer, but he's taking direction from a freeloading surf bum in one of the bungalows on the property, just all over the damn map.
You couldn't interrupt him writing the search warrant to see if it was okay to talk with the next door neighbor's maid?
I didn't think it important.
Didn't think it important. Did you cause her to ask her gardener some questions?
Excuse me?
Did you cause Rosa Lopez to ask her gardener some questions?
Not at all.
Were you looking for possible sharp objects when you were on the Salinger property?
I was looking for anything that looked like it was unusual or something that was obvious.
Was one of the unusual things you were looking for, Detective Furman, a sharp object?
I didn't know at that time the cause of death at Bundy, so I didn't know what I was looking for precisely.
Can you answer the question? Were you looking?
And that's a lie, by the way. He said he distinctly saw lacerations on the bodies. That's a lie that Bailey doesn't catch him on. Bailey just wants to pin him down on this. Were you looking for sharp objects?
Detective Furman, a sharp object.
I didn't know at that time the cause of death at Bundy, so I didn't know what I was looking for
Liar.
precisely.
Can you answer the question? Were you looking or were you not looking for a sharp object?
I can't answer that as a yes or no, sir.
So you don't know if you'd seen a knife, whether you'd have picked it up or photographed it or even noted it?
I wasn't specifically looking for a knife. If I would have found one, I would have seized it, yes, or kept it there for a photographer and a criminalist to recover, yes.
Okay. Now, what else were you looking for? If it wasn't knives, what were you
yes,
hoping to
he's the
find?
racist detective.
I don't know,
He wasn't
sir.
looking for
Anything that
knives.
looked like it was out of place or possible evidence. I could go back to the Salinger residence and ask if it was theirs.
Bloody clothing?
Anything of that nature, yes.
Had you seen enough of the crime scene to assume that whoever had perpetrated the murders probably had blood on them, as the gloves did?
Yes.
All right. Were you interested in finding whether or not there was any bloody clothing nearby the Simpson residence?
I don't think I was specifically looking for just that, but as I said,
Detective Furman, when I ask you if you're looking for something, that does not mean to the exclusion of all other items. I simply want to know if that was on the list of things. That
Just
might have
say yes, I was
interested
looking
you
for a
if you had
fucking
seen it.
knife.
there was no list.
There was no list.
For fuck's sakes. Why not just say yes, we were looking
You know
for a
how
knife,
you were
a
going
gun,
to
a
decide
stapler,
whether
a
something was
club, a
significant
baseball bat,
if it
any
walked up
fucking
and
thing
hit
that
you in the
could
face?
kill another human?
Well, if it didn't belong in the Salinger residence and it came from the Simpson residence, it could be possibly construed as something involved with anything to do with Bundy or Rockingham, and I'd simply ask the Salingers.
Well, my question to you was simply, included among those kinds of items, would bloody clothes have been an item?
Yes.
All right. Did you find any?
No.
Did you find any sharp instruments?
No, sir.
Was the gardener
Oh,
working?
this
that
guy's
Monday
way
morning?
worse so far.
I saw a gardener sometime that morning, but I'm not sure if it was in front of Salinger's residence or on the street.
You never saw the Salingers there, did you?
I don't know. I don't believe so.
The only person you spoke to at the front door was rather short, Hispanic, upper middle age, correct?
No, because I believe there was a security door with some type of a mesh where I can't see in. That person opened the interior door.
You
and
can't
spoke
see through
that.
mesh?
If the person who spoke to you that morning presented themselves in this courtroom now and didn't say anything, would you be able to recognize them?
No.
Was the accent accompanying the voice, which had no image at that point, Spanish or Hispanic?
I don't recall that there was a heavy accent, no.
Do you recall any accent that would tend to identify the speaker as someone born in another country?
It's a possibility, but I don't recall it.
Okay. And when was the first time you ever spoke to anybody about this encounter with the person at the Salinger?
I believe
Unfortunately,
when
Pokemons didn't
Rosa
exist back then.
Lopez came forward as a witness.
So, you mean when she was first listed by the defense a long time ago or recently?
I'm not sure on that, sir. I don't know when she was listed, and I don't know when she testified exactly. So I would probably say sometime in between there.
Did you ever learn, as a result of any hearings before this court, without going into what was said, that it was alleged that you had talked with Ms.
Not
Lopez
only
in the
did
morning?
Pokemons
the
not exist,
investigation.
Latinx didn't exist
heard
either
that.
back
I
then.
remember when you first learned that.
No.
Oh God, that rum
Have
went
you
down
ever
way
made
too
any
fast.
effort since that time to get a look at Ms. Lopez to see whether or not, or listen to Ms. Lopez to see whether or not you could recognize that person as the one you may have talked to on the morning of the 13th?
Yes, I saw her on the news.
All right. And did you listen to her?
Yes.
Did that help you in any way as to whether or not this is the person you questioned on the morning of the 13th?
Well, she was speaking Spanish, so no.
Did not hear her speak English?
No, sir.
Did not hear her.
He
here on the
cannot
witness stand
agree with the
testify?
defense on anything.
No, I saw a clip on the news. I believe it was of her testimony.
Okay.
The jury hates this shit, by the way.
To this day, by the way, do you know what, if any, portion of the neighborhood around the Simpson home was searched for these items of evidence that you and I have been discussing, such as weapons and clothing?
No, sir.
You never participated in, gave any direction to other officers about, or otherwise involved yourself in a search for items of evidence of this sort?
I was there during the search warrant, and I assisted in the closet of Mr. Simpson's bedroom
Assisted with the closet.
and some of the exterior portions, but that's it.
Who was the first person, if you know, by the way, ever to go up to Mr. Simpson's bedroom after you entered the premises?
I don't know, sir.
What time did you go there first?
Inside the residence
Yes.
with Mr. Kalin.
Rum and Coke. Well, rum and Pepsi. Lime.
How great an area, if you know, around Bundy was searched for bloody clothing, other accoutrements might have been worn or used by the murderer, including a weapon?
I have no knowledge of that, sir.
Didn't Officer Risky tell you where he had caused people to look for items of that sort?
I don't recall that, no.
Did you continue working on this case after June 13th?
I believe I was asked to do a few things. Yes.
Joseph Cooper, you stick
Did you know
around
that
and listen. You
Detective
can mix and
Van Adder
match
said
these.
on June 6th in his sworn
Listen to this
testimony
and then
that
go
you were
back and watch
still
the rest.
Very much a part of the case as a detective.
Well, I think that would include the times that they ask us to do certain things, yes.
All right. And when did you last do any work on this case, Detective Furman? Other than prepare yourself as a witness?
It would have been last year, sir.
I
Maybe-
understand.
Maybe a month after the crime.
You think you may have continued through July to work on the case?
Yes, there might have been some things I did, yes.
And some part of August, you may have worked on the case?
I'm not sure, sir.
All right, well, assuming that jury selection or proceedings pointed toward jury selection began September 19th of 1994, did you do any work on the case after that?
I can't remember, sir.
The
You
detective
don't
can't
know
remember
whether
if he
you've
did
done
work.
anything on the case since this proceeding began.
I don't believe I have, no.
Did you receive an instruction of some sort, Detective Furman, to abstain from viewing these proceedings?
Yes.
And have you followed that instruction?
Yes, sir.
Now, over the lunch hour, did you have any chance to reflect or have your memory assisted by any of the minions for the prosecution as to the sessions that occurred before the trial?
Okay. Again, this line of questioning goes back to 1 and 2 episodes ago, where I mean, clearly he's being prepared for trial. He's one of the star witnesses for the prosecution. Clearly they're preparing him for trial. And Bailey was just asking Fuhrman about his preparations for trial. How this goes in the real world, in the non-OJ Simpson, Mark Fuhrman, F. Lee Bailey world. Officer whoever, did you meet with the prosecutor and did they prepare you for testimony? Yes, I met with the prosecutors. They guided me through the process and prepared me for the trial. They did not coach me. They just guided me through the process. And that's usually how it ends. But no. Fuhrman's got to deny it. How many times did you meet with the prosecutors to prepare for the trial? Oh, I don't remember. Well, was it 1? Was it 100? I don't remember. Well, did you meet with them in the last 6 weeks? I don't know. Maybe once. Well, how many times did you meet with him this month? How many times did you meet with him in the last 2 weeks? And he was just obfuscating the whole time. And he eventually pinned them down to, I think it was 3 or 4 times he met with them. But did they ask you any questions about this? No. Did they ask you about your use of racial terminology? No. How many questions did they ask you? And that was one of the funny parts when they said, well, this one particular preparation meeting, how many lawyers were there? There was 3 lawyers. Do you remember who they were? No. How many questions did they ask? Oh, only 7 or 8 questions. And Bailey says, so you're telling me that 3 lawyers only asked 7 or 8 questions? It was, yeah, first he said less than 10 questions. And he said, well, was it 1 or was it 10? He said, well, maybe 8. Why 8? Well, because 8 seems like a good number. It's less than 10. And I was like, oh God, it's just awful. He can't remember how many times he met with the prosecution. He literally said he cannot remember a single question he was asked by them in preparation for the trial. He couldn't remember when, where, or how he met any of them. It was just a disaster. And now he's asking him, did you have time to reflect on that bullshit testimony you gave earlier today?
Assisted by any of the minions for the prosecution as to the sessions that occurred before the trial, your part of this trial, and since the first of the year?
No.
Would you say, Detective Fuhrman, that in addition to this being the largest case in which you've ever been involved, this is perhaps the most important testimony in which you've ever been involved?
Sustained.
Have you not been very concerned since January 1 and beyond with the experience of testifying in this case?
Say something stupid.
I believe I was concerned with the allegations that have been brought forth against me.
Yes.
Yes.
And those are the allegations that he's a racist and he planted evidence. Those are the things he was concerned about. And we've clearly shown, well, Bailey has cross-examined him about whether he's a racist or not, whether he's used the N-word at any time in the past 10 years. Never, ever, ever. I don't ever, ever, ever use that word. I never describe people that way. So F. Lee Bailey asks, if anyone comes here and sits on this stand and testifies that you have used that word at any time in the last 10 years, they are, by definition, a liar. And he says, yes, they are a liar. So they hasn't been proven to be a liar or a racist in that regard, but that happens in a few months, or for us, either next week or the week after that, when he gets the people on the stand and they testify and they bring recordings, spoiler alert, and planting the evidence, which, mysteriously, again, he's the only one. Well, we won't even get back into that. We just go back and you can watch it. So that's what he's worried about. He's not worried about the actual murder and in murder investigation at this point. He's not worried about testifying. He's worried about his reputation and the allegations of he's a racist and an evidence planter.
We're concerned with something happening, which has now happened, correct?
No, objection.
Sustained.
Withdrawn. Having that in mind, Detective Furman, were you anxious that you deliver a good performance on the witness stand?
Objection, argumentative.
Overruled.
How is that argumentative, Marcia? Shut up.
I'm always concerned with that in every case.
In this case, more than others, Detective Furman?
I am testifying just like I do in any other case.
Mm-hmm. And have you ever, in any other case, faced accusations such as you expected in this case?
Oh.
Sustained.
See, Bailey is a fucking master at this cross-examination. He absolutely knows where he's going, regardless of how he's got the full narrative planned out, and he knows is branching paths. If yes, you go down this path. If he says no, you go down this path. And that is a perfect question for those of you that have been in the military. You know, it's like the drill sergeant or the drill instructor asking you, do you like doing push-ups? Well, no. We'll get down there and do push-ups until you like them. Or do you like doing push-ups? Why, yes. Well, get down there and do push-ups if you love them so much. It's the same way with him. Was this important to you? No, I was testifying just like I would testify at anywhere else. Well, in other cases, have you been accused of being a racist and an evidence planter? He's just brutally riding him bareback without the use of lube and putting him away wet, raw, and bleeding. I'm sorry, that was rather graphic.
And have you ever, in any other case, faced accusations such as you expected in this case?
Sustained.
Have you ever, in any other case, had the benefit? May I finish the question? Have you ever, in any other case, had the benefit of a grand jury case preparation session such as you had here?
Overruled. Denied.
Hmm.
You can answer the question.
No.
I thought we already asked that once before.
Judge Ito, it's not your place to say that.
No. Having in mind all of that, do you maintain that you have almost no recollection of the sessions intended to prepare you for this testimony?
That's correct, sir.
Overruled.
Have we solved the earlier problem, Your Honor? Described it.
Nothing has been submitted to me.
I understood that it was coming forth with.
Now they're talking about an earlier problem. He said, have we solved the earlier problem? And what that is there was testimony for us several weeks ago, but for him a couple of days ago, that he has sued the defense team and I believe Newsweek and some other people for saying he was a racist and planted evidence. And his lawyer, his civil lawyer, sent out a letter saying he needs to raise $100,000 to cover incurred legal expenses. That was like crowdfunding before there was online crowdfunding. His lawyer sends out letters to other police officers and other things asking for money to help Mark Fuhrman cover his legal expenses. It turns out that they wanted a copy of the letter. They wanted his lawyer to come in and testify about the letter because they're saying that proves Mark Fuhrman has a financial motive in the outcome of this case. The implication being that Mark Fuhrman will lie or do anything necessary to make sure OJ Simpson is convicted, because if OJ Simpson gets off, that can show that maybe the jury thought he'd planted the evidence or he was a racist. But if OJ Simpson is convicted by a jury of the peers, that means he's off the hook for being a racist evidence planter because they accepted the evidence. And so they want to show that Mark Fuhrman has a huge financial advantage in the outcome of this case. And also, F. Lee Bailey raised the possibility that the lawyer stated in the statement that he needs to cover the $100,000 expenses that have been incurred, meaning already past tense. And F. Lee Bailey raises the specter of he needs to come with receipts, because if their lawyer sends these letters out saying that he's incurred $100,000 in fees and needs them covered, and it hasn't incurred actually that many fees, that amounts to federal mail fraud. So Bailey's going for the throat. And that's what they're talking about here. Is his lawyer going to come in, bring a clear copy of the letter, and is he going to testify? And Ito says, I don't know, but he'll come in here in a little bit. And while we're paused here, let's just take a little break and welcome the Meme Copium people. We've got a Meme Copium raid. Meme, if you're here, howdy. Meme Copium viewers, you're here, so howdy to you. Right now, we've got 300 viewers exactly and 149 likes. We are under 100. We are under 50%. This OJ Simpson is the least watched. This is the weakest stream we do every week, but I'm doing it anyway because I think it's entertaining. I mean, normally these are numbers that people just go, all right, fuck it, this isn't working, let's do something else. But I think this is important, so I'm doing it. Forget the numbers. All I would ask you to do is make sure you hit that like button. That's the only thing I can ask for in this situation. I mean, there's not a huge amount of revenue that's coming in. You know, the super chats aren't a big deal. On Simpson night, I just want the likes so we can get YouTube to put us in the algorithm, can recommend us to more people. So the more likes we have, the better it is. We've got 331 people now and 181 likes. So please, all of you that have not yet hit the like button, if you've been here more than 30 seconds, you clearly like what we're doing. So do me a favor, consciously take time off what you're doing now and hit that like button. Let's get us up there. That would mean a whole bunch to me. And if you haven't subscribed, please feel free to do that. This is what we do. I've given you the weekend preview. OJ Simpson, Courtney Clenny, the OnlyFans murderers, Barbara Stabarella, as we're calling her, more Maritime Monday. Then we're going to go to Idaho slangs, Taylor Shabusiness. Then we're going to go to the Colorado murders. And then we're going to go back to Simpson. So that's what's coming on. So again, we're all right. We're almost up to 200 likes now. That is a super thing. Thank you guys so much for heeding the call. Let's burn through a few comments and super chats. All righty. Let's bring those up and then we'll jump back into the trial. Don't want to get too far behind on the super chats and the chats that I just found amusing. Super chat. Guy Vermectin. Oh, thank you so much. Let's get this started. All right. Thank you so much for that. Anybody that wants to follow his lead, the super chats, there's no minimum requirement. It's not a thing. I grift the likes much more than I grift the super chats, but if you do choose to super chat and throw your hard-earned money at me in support, I guarantee you I will answer your questions. I will respond to your questions with priority, regardless of the amount. I know some people say there's a minimum amount of super chat before I'll even deign to speak to you. That's not me. You know, $2 to someone can be the same as $500 to another person. It's your hard-earned money that you're just throwing at me for whatever reason. So I respect all super chats, read them all, and deal with them all. That's it. Thank you so much, Guy Vermectin, for that. Bringing up the super chat. And Kitty says, Jeff, did you have your Subways? We Subway sandwich. The prosecutor in the Courtney Clenny bond hearing kept calling it Subways. Yes, I had my Subway turkey sandwich today. Okay, in fairness, no, they didn't have any turkey. So my Thanksgiving dinner was a sliced chicken, bacon, and avocado Subway's sandwich. But Saturday, a bunch of us Americans are getting together and having a real Thanksgiving dinner. Alfred Sparman, I mean, at this point, now this is an important thing to note. I mean, at this point, if I'm on the jury, I'm not believing a fucking thing this man says. That's important because that's how reasonable doubt gets in the minds of the jury. They say, okay, this guy is obviously full of crap. He's lying, he's obfuscating, he's hiding, he's hedging, he's hemming and hawing and denying things. He's saying dumb shit that nobody needs to say. So I can't believe a thing he says. That goes straight to the fact that if you can't believe him or trust him on anything, that means you have to throw out the bloodstains that he found all by himself on the Bronco. That means you have to throw out the bloody glove that he found behind the building on his own with no direction. So you can't believe him. You can't believe the evidence he found. And at this point, what do you have? If you don't have blood on the Bronco, you don't have a bloody glove. This is exactly how reasonable doubt gets planted in the minds of jurors by cops who think they're smarter than the defense lawyers, who think they're clever dicks, who think that they know how to get around things and are just argumentative because they don't want to agree with a single thing the defense says. This is how it happens. It's unnecessary. It's damaging. And as I said a few minutes ago, This guy right here on the stand, Mark Fuhrman, is one of the primary reasons why the prosecution lost this case. And 99%, which is a figure I've pulled completely out of my ass, but what I mean is the vast majority of his lies and obfuscations are completely unnecessary. Well, they're all completely unnecessary, except for maybe, I can see maybe trying to hide the racist part. But all of these little petty disagreements and refusal to cooperate with the defense's questions are unnecessary, makes you look stupid, and prejudices the jury against you, and they know you're lying, and then they just throw out your testimony. Fedorovsky says, Alan, Pepsi Libre, that's what I'm drinking. Well, now it's just Pepsi and rum because I don't have any lime in it. So technically it's not even a Pepsi Libre at the moment. Arto Risanen says, Cochran, I choose you. Pokemon Master wins again. that was solid. Givener, did I hear that this guy is still with the police? No, he's not still with the police. He retired or was retired shortly after this. He moved up to Coeur d'Alene, Idaho. He actually did a very good job assisting independently as a private investigator in another case in Idaho back in the day. And now he's reared his head and has started to comment on the University of Idaho stabbings last week. We'll get into his statements next Tuesday. PG Farber, I'd rather be questioned by Elaine Bredehoff than F. Lee Bailey. Yeah. And once we get done with F. Lee Bailey and Mark Fuhrman, we'll take a day and just show you some interviews and some things with F. Lee Bailey that are just F. Lee Bailey is one of my heroes. So that's why I love this testimony. This is like watching, well, this is watching a master at work. This isn't like watching a master at work. JK DeBuch. Did OJ ask for his hat and glove back after the trial? That's funny. I like that. That was a good, solid comment. He goes back to the evidence locker. Can I have those back now? And he could, whether he did it or not. As soon as the jury says, we find Orenthal Jane Simpson not guilty, he can go, fuck yeah, I did it. And there's not a thing they could do about it. He could literally walk to the police station, into the evidence room and go, phew, now that that's over, can I have my hat and gloves back? And there's not a goddamn thing they can do about it. And finally, Rhode Isle 1313, Legal Vices, putting him away wet, raw, and bleeding like OJ did to Nicole. Yikes. That was solid. That was a solid comment. All right. So with that, again, we are at, we've got another one. TX Carey, keep this content coming, please. I absolutely intend to do it. Like I said, this isn't the most watched thing I do. This is, in fact, the absolute least watched thing I do. And it takes a day out of the week, but I like it. It's interesting to me, and I'm going to keep with it because I know some of you come here for this. So that's why we're here. I don't mind. I like it, so I'm doing it. I did not miss I just read this. I did not miss it. Just patience. All right, let's get back to this questioning.
Solve the earlier problem, Your Honor.
The earlier problem of the lawyer who was demanding $100,000.
I understood that it was coming forth with. Have we learned the status of that, perhaps?
Ms. Lewis?
Nice one, Mr. Terrible. All right, little internal conversation with the defense team. And right now, by the way, I'm committing blasphemy. I'm committing treason before Korea. The World Cup is on. Korea is in the middle of playing Uruguay right now. Literally, of the 40 million people in Korea right now, I am the only one that is not watching the World Cup. Literally everyone else on this entire peninsula is watching the World Cup except me because I'm here with you. I promised you. So I'm here for you. My friends are you watching it? I mean, no, what's up? All right. Bailey, come on, talk to us here. I'm just taking this time to message all my friends and tell them to stop texting me about the damn game. All right. Come on, guys. All right, let's fast forward this here.
Use the time profitably.
There we go.
Didn't want to interrupt the conference of my colleagues, but I would certainly like to do that.
I'm sure Legal Mindset's watching too.
Detective Furman, as I recall, your initial arrival at the Ashford Gate and in the developments that occurred thereafter, including the observations about the Bronco, you were concerned that somebody might be bleeding to death, including OJ Simpson, inside his house, right?
I said somebody. I didn't use the word OJ Simpson.
No.
Yes, sir.
I'm adding it. Wasn't he one of the people that could have been bleeding to death in the OJ Simpson house?
Yes, sir.
When you got into that house finally and started talking to people, did you ever ask anyone where OJ was?
No.
Be Catholic. What does that have to do with
The question I
anything?
have, Your Honor, is related to
Where'd that come from, Patty?
document, which I assume is en route.
All right.
All
All right,
right,
ladies
they're-
and gentlemen,
They're going to take a break and bring the lawyer, the civil lawyer from Mark Furman in and question the shit out of him
Give you enough time
about
for a
the
comfort break.
demand
All right,
and
Detective Furman,
the
you can step
request for
down. Stand at
$100,000 in fees. That's fun. Wow, they're back magically.
All right, back on record in the Simpson matter. All parties are again present. The jury is not present. I have now received what appears to be a photocopy of a fax. Yes, please. Thank you. All right, I reviewed this, what appears to be a clear and full-size copy of a letter dated September 21st, 1994, addressed to a Daniel Labato of the Northampton Police Department, Northampton, Massachusetts. All right, either counsel wish to address this issue, or do you want to proceed with the jury?
The people have addressed the court on the issue of relevance.
All right, well, I indicated I wanted to wait until I had the chance to read the entire thing, and it, without any passages being obscure, I'm now ready to hear that. Mr. Bailey.
Your Honor, I believe that the letter plainly seeks to advance the financial position of
All right, this is
Detective Furman to
the question
extent
about the
that
financial letter.
in seeking counsel, one assumes that expenses and fees would arise. This letter, which proclaims the high moral character of Detective Furman and declaims false accusations of racism, seeks to have police officers, and I believe it went around the country, contribute to make up the costs that had been incurred and
Costs that
expected to
had
be
been
incurred.
incurred.
it lists some of the salient victories of the Tortolo firm in representing Furman and claims that Tortolo and Butler had fronted out-of-pocket costs which have already reached over $100,000. To clear his good name, the cost of experts, investigators, and paralegals continue to mount at a rate we can no longer sustain. Ground one, I believe that any money contributed as a substitute for something that Detective Furman would owe as a legitimate fee or cost of representation, if there were any, is a significant financial advantage to him. Second, he says he's familiar with the letter. I think we're entitled to ask him which portions of the letter he was aware of before they went out. And third, I think we're entitled to inquire whether anything approaching $100,000 in costs had been incurred by September 21, 1994, or whether the United States mails were used for a fraudulent attempt to obtain money by making misrepresentations as to costs, which recipients would hardly be in a position to second guess.
You want to explain to the court how it is that this letter relates to any bias, interest, or motive as
Please
it
do.
pertains to Detective Furman's testimony?
How does this
today?
demand
Yes,
for
I do.
$100,000 have
Presumably,
any tie to
His
to
testimony
Furman.
is accepted or admired by the recipients of this letter. The solicitation is still hanging out there. If he can convince them that he's a good guy and he's telling the truth, OJ Simpson's a bad guy, some of this money may come in. But I don't believe in an undertaking of this sort that the result is necessarily essential. It is the purpose of the exercise.
All right. Ms. Clark?
That is tortured logic, to say the least, Your Honor.
Not really.
The witness is here in court to present testimony concerning the work he did in this case. He's not here soliciting funds for anything. Number one, this letter is irrelevant to any issue of bias or detective's credibility. Number two, with respect to how monies have been spent in the mounting of the lawsuits for defamation, is privileged. So counsel's not permitted to get into that. I cannot see any relevance to this letter pertinent to this detective's testimony. I mean, it's just absolutely absent.
Well, the issue, as I understand Mr. Bailey's argument, is that there is some potential for financial gain that would impact on motivations to testify or how to testify. Do you want to address that particular?
Yep.
Not reflected in this letter, there isn't, Your Honor. What this letter reflects is the need
Marsha,
to
Marsha,
defray costs
Marsha.
of legal expenses incurred as a result of lawsuits which were made necessary by the defamatory nature of the false allegations made against Detective Furman. But there's no financial gain involved in that pertains to his testimony. The two are totally disparate. He's testifying here today, and this letter was generated when? Back in September, long before he took this witness stand, in an effort to defray legal costs. His appearance today has no bearing. There's just no connection between his appearance in court and this letter and the money it seeks to get. And we're talking about defraying legal costs that were made necessary by virtue of the actions of the lawyers for the defense in this case. So there is no gain to Detective Furman in that regard. And it has not been shown that there is any, nor that there ever will be. To the extent that the court sees there is a financial interest this witness has in having at least begun work or contemplated lawsuits for defamation against the lawyers in this case, that has already been explored. And that issue is not illuminated in any respect by this letter, other than to indicate that he doesn't really have the money to pay for these lawyers. I do not see how it can have anything to do with Detective Furman's credibility on the witness stand, especially in view of the fact that Detective Furman never read the letter. This is something issued by his lawyer, the work product of his lawyer. As
80s
was
weren't
the
perms.
decision as
80s
to
was
who
the
to sue and
hairspray,
what
big
to,
hair
and what to sue them
days.
for, was the work of his lawyer. I understand the agency theories, Your Honor. I'm not arguing with that. But this letter was not generated at the behest of Detective Furman. And I think that's an important distinction to make.
Well, when you call something, though, the Mark Furman Justice Fund, and it's issued by your attorney,
Jerry Curls.
don't you think that any attorney would send a copy of these things out for approval by the client before they're sent out, especially if you're talking about a nationwide
Farrah
fundraising
Fawcett,
campaign?
the red
and the amount of
bikini
money
hair.
that takes. I mean, just in postage, you're talking a substantial amount of money.
Well, leaving that to one side, Detective Furman has indicated he's aware a letter went out that he did not read, that his lawyer drafted. But, you know, do we really want to do this, Your Honor? Do we really want to spend 2 hours now talking about how Detective Furman's lawyer is saying he needs to defray legal costs incurred as a result of the defamation suits that may be filed at the end of this case, which have not been filed yet? I mean, is that where this case is going?
Yeah.
How far afield do we have to go on this witness? I mean, we have gone way out there in the past 10 years. Have you ever used a racial slur? and a woman who makes
But he
allegations
said
about him 10
no.
years ago. And
But he said no. That's why it became an issue, Marcia. If he would have said, yes, every cop uses the word, yes, I said it years ago when I was talking to a screenwriter. Yes, I said it years ago when I was trying to be a tough guy in a Marine recruiting station. Then he could have gotten in front of it. But he said no, and it became an issue. It became relevant, Marcia. You can't go back and rely on that.
and what other cases he's ever testified in. And I mean, we have really hit the outer limits here, and this is far beyond the outer.
Yeah, it's far beyond the outer limits. We've hit the outer limits until he brings those witnesses in a few months and sits them down and talks to them about that and brings the tapes, Marcia Clark. And now his financial interest in the outcome of this case goes directly to his framing, his planting evidence, his racism, his efforts to make sure OJ Simpson goes down. If that happens, he gets a financial benefit from this.
Outer limits. This is the twilight zone. This letter really has no bearing on this detective's credibility, Your Honor.
Go to your room,
It's a letter
Geiger
he
Becton.
himself has not drafted. And I understand what the court is saying. He gave permission for it to go out, but the language contained in it, which Mr. Bailey is going to want to attribute to him, is not his language. So
He gave permission for it to go out, but it wasn't his language. What the fuck do you think it means to give permission for it to go out? That means you've read it and you say, okay, I like this. I like the way it's written. I agree with the way it's written. Therefore, please send it out. Please send it out. By agreeing to send that out, you are agreeing with the words included in it. Marcia, that letter is attributed to him by virtue of him agreeing to send out a Mark Fuhrman Defense Fund letter on behalf of Mark Fuhrman, approved by Mark Fuhrman.
saying he gave permission for it to go out, but the language contained in it, which Mr. Bailey is going to want to attribute to him, is not his language. So we're creating an unfair inference that Detective Fuhrman wrote a letter, put language in it, and solicited an amount of money that he did not do. This is the work of his lawyer for the purpose of defraying legal costs. And it is privileged material. Especially because Mr. Bailey has now said that he wants to explore exactly how much money
serious
was
argument
spent,
of the time.
and whether $100,000 is a fair representation. I can assure the court that it is, and the paperwork exists, but it's nobody's business. It's privileged.
No, don't shut up, Patty. That's a valid argument. I mean, it's an argument that can be validly made.
Yes.
Mr. Fuhrman going to assert that privilege?
Yes. This is not territory that I think is really proper for Mr. Bailey to explore with this witness.
Well, the judge
For that matter,
disagrees.
but I mean, this is privileged material, and
Not really.
that Mr. Bailey wants to get into. And the real thrust of his cross-examination on this is whether $100,000 was really drummed up in
Well, of course,
costs or not.
because if it wasn't
That's a
drummed up,
privileged issue.
the lawyer is guilty of mail
Will
fraud.
the court permit us to go into how much a witness who testifies in this court who happens to have a lawyer is paying that lawyer to
No,
represent
because
them
they
as a
didn't
witness in this
say
case?
anything about how many costs they'd incurred.
Wait a minute.
Rosa Lopez, we talked about it, remember?
Yeah.
But did
Oh, yeah. I forgot about that. Hang
Lawyer
on.
is paying that lawyer to represent them as a witness in this case? Wait a minute.
Rosa Lopez, we talked about it, remember?
Yeah, she just got caught. I forgot that was coming up. So yeah, can we talk about how much they're getting paid to do this? How many legal? And that was one of the things she asked the neighbor Rosa Lopez about, was how much money she had incurred in costs and how much. So yeah, she just got nailed. She just got nailed sitting up on her almighty high pony horse thing there, and to the point that everybody in the gallery is laughing at her because she overextended and said dumb shit. L Fox, thank you so much for the super chat. Happy Thanksgiving, Lorax. Well, happy Thanksgiving to you, L Fox. Love Maritime Mondays, and I'm thankful for everyone's continued health. And me too. Blessings for everyone for continued health, and those of you that are infirm for better health. Peace, love, and happiness here on this American Thanksgiving holiday. Let's get back to the burning Marcia Clark at the stake.
But did we,
Fee arrangements, remember?
but they didn't assert it.
That's true, but I allowed the inquiry, didn't I?
Only after they conferred. That was cleared first. I remember Mr. Darden went over to Carl Jones.
Marcia,
Went
shut
over
the
to Carl
fuck up.
Jones and asked him, hey, I'm going to go into the fee arrangements. Carl Jones waived any privilege and said that was fine.
Marcia,
He did not assert the privilege, and he could have. He was given every opportunity. The court flagged the issue for him,
sit down.
and he elected not to do so.
As I am doing here.
Is that,
We want to turn a little down here, Your Honor.
is that what?
Well, I don't think that, Ms. Clark, with all due respect, I don't think you're in a position to claim on Detective Furman's behalf.
No.
So either Detective Furman himself has to claim the privilege or his attorney on his behalf.
I think probably it'd be most appropriate if his attorney did so, Your Honor.
Ought to be heard on waiver, Your Honor?
Well, let's hear from Mr. Tortolo if he's available.
That's not Eddie Cochran. That's Johnny Cochran. Eddie Cochran was a musician. Everybody's got the cure for the summertime blues. That's Eddie Cochran. This is Johnny Cochran. Different animals.
It's different here. With respect to Rosa Lopez, Carl Jones was representing her in her capacity as a witness. No other capacity. She wasn't filing any lawsuits. She had no independent legal cause of action going. And Detective Furman does, because he's not being represented by Mr. Turtolo.
Well, but the testimony so far, hasn't it been that Mr. Furman has not filed any lawsuits yet?
That's right.
So there are no causes of action pending, are there?
That's correct.
Same
But-
difference.
No, it's not. No, it's not. Not at all. Because Mr. Turtolo is representing Detective Furman with respect to what may
Well,
be filed,
Ms. Clark,
and it has
right.
nothing to do with,
Hold on. The issue is there somebody
Oh, shut up, Marcia.
plausibly
Jack Matt says Effley Bailey had his law license revoked. He was disbarred right there towards the end of his life. He got involved with a little bit of playing shell games with drug dealer client money. Some may call it money laundering. Others just may call it misappropriation of client funds. But yeah, he kind of got he got nailed for doing some unethical stuff and got his law license in all of the states he was qualified in ripped. He desperately tried to get him back, and I'm not sure if he ever got any of his licenses back. But yeah, just the last few years of his life besmirched an amazing, illustrious career.
who can raise an attorney-client issue here regarding the area of costs. Maybe. That's what I've determined.
Didn't know Joe Cocker was a lawyer.
So rather than
trial.
argue apples and oranges
No,
between
that's not
Rosa
how it
Lopez's
works.
situation and Detective Furman's situation, it's an interesting discussion, but I don't think it really bears upon the specific issue regarding this letter.
And Chelsea Allen, new sub, found you through the OJ coverage. Seriously? Wow, that's great. So glad to have you here because of this coverage. I'd always wanted to understand how it was he wasn't found guilty, and thanks to you, now I understand.
I don't know what it is. This is the body of the letter. He took credit for rulings you made in Furman's favor.
Oh yeah, that was in the letter. His civil lawyer was taking credit for influencing Ito, making decisions about the case. But to Chelsea Allen, thank you so much for joining us here because of this. And again, that's what I said. I'm not here to change anybody's mind. This happened 27 years ago. You've all made up your mind whether he's guilty or innocent, whether he did it or he didn't do it, whether he did it or didn't do it or was there and watched it happen, or whether he hired someone or whether his son did it or whatever the hell other theory of the case you may have. You've all made up your minds. This isn't going to change any of it. I am just doing this exclusively for the purpose of showing you amazing lawyering and how it can lead to a jury finding reasonable doubt. That's it. Now let's watch Marcia Clark squirm a little bit more because she just can't shut her face.
That's not representing a witness. I don't know what it is. This is the body of the letter. He took credit for rulings you made in Furman's favor.
What? What? What?
I don't take any credit except Your Honor for Your Honor's rulings.
We've won 2 recent victories.
Yeah, the letter said we've won 2 recent victories.
No, I don't score it that way either.
You don't score it that way?
No.
First Judge Ito denied the defense team's right to review Mark's record. That's one of the victories.
Ms. Clark, did Ms. Lewis step out to find Mr. Tortolo? Fine. Yeah, Mr. Bailey, I understand this is about the last area of inquiry that you're going to make at this point.
Remember, Evelyn was before Viagra. This old dude was able to get hard on pure
No, I'm
masculine
just saying this
lawyering.
particular issue
Damn straight.
is the last issue on cross. Unless something leaps
And like
out
I
at
said,
you.
we'll watch some
Overnight.
interviews with
Phone keeps
F. Lee
ringing.
Bailey
Something
that are just
came in.
amazing.
But it is, so far as I know, except
After all
for a
this is done.
question prompted by the last phone call, which is very brief.
All right.
Now they're going to bring in his civil lawyer and question the hell out of him for a bit.
Impeachment witness.
No, I was just trying for scheduling reasons to see maybe we could at least wrap up the cross today.
Right, I appreciate that, but I'm talking about discovery reasons.
Well, if we're going to wrap it up, I assume there's nothing more to discover.
Why would you assume that, Your Honor?
Well, I guess that was more wishful thinking.
Mine too.
Yeah.
But if counsel is referring to another witness that they intend to proffer, the people are entitled to know about it.
I'm not.
Huh. All right, while they're doing all this, I'm going to do my sort of semi midstream grift here. 401 concurrent viewers, 400 concurrent viewers, 253 likes. That's close enough to have to make me
Low.
nervous.
Good afternoon,
Please
sir.
reach down there and hit that like button. And here is his civil lawyer, Mr. Tortolo.
Are you familiar with the letter dated September the 21st, 1994,
Yes.
addressed to a Daniel Lobato of the Northampton Police Department?
Yes, I am, Your Honor.
All right. The issue has been raised in the cross-examination of your client, Mr. Furman, concerning any potential monetary interest he may have in the outcome of this litigation. And this letter has been proffered to the court as some indicia of monetary interest in the outcome of this litigation. And specifically the issue of the paragraph that indicates that your law firm has been fronting, so to speak, the out-of-pocket expenses that have reached over $100,000. And Mr. Bailey has indicated he wishes to cross-examine in that area. And in our discussion, prosecution has raised an objection of relevancy and 352, an undue consumption of time as to that issue. And I don't recall specifically who it was who also opined that there perhaps is an attorney-client issue regarding the specifics of the representation, the parameters, the costs, and that sort of thing. And there's also a potential of waiver if, in fact, this letter itself was published and constitutes a waiver of that.
Well, number one, I will represent to the court that we have expended, including attorney's fees,
Newt
in
Gingrich.
excess of $100,000 as of the date of that letter. That's number one. Number two, I'll represent to the court that Detective Furman, to my knowledge, had never seen the letter. I have never given him the letter. I asked him if we could send out a letter to cover secretarial, expert fees.
Okay, two things here.
investigators, and
Two
paralegals.
things here. One, Jack Matt, Tip O'Neill. Tip O'Neill, really? Tip O'Neill? What? Okay. There's two things. One has a subset. One, Tip O'Neill, and sub 1A, Tip O'Neill. Jack, I'm sorry, my friend. You're old as fuck if you know who Tip O'Neill is. And, you know, I'm right there too. And sub AB, he really does look like Tip O'Neill, doesn't he? Okay, and the other thing, which I've just forgotten. Oh yeah. This lawyer just said that his client never saw the letter that he sent out on behalf of his client. So his Mark Fuhrman sent something out on it, agreed to send something out on his own behalf that he never read. That has all kinds of problems. All kinds of problems. Wow. All right, let's continue. Jack, go take your Geritol and sit back down and enjoy the trial.
Eagles. If the letter isn't clear, I'll make it very clear. We have made it an arrangement, Mr. Fuhrman, that we were not charging him 1 cent. We have not charged him a penny. We do not intend to charge him a penny, and that we were doing it pro bono. And that's what the letter is meant to imply. But we cannot continue, as of September, we could not continue to front and put up all of the costs that we've been putting up in paralegals.
We're doing it pro bono, but not really. That's what he just said. I don't know. Is it?
Your
I have
Honor,
no idea. I'm too old.
We do claim the privilege. I wanted to explain why.
This lawyer is such a shit lawyer that the prosecutor has to get him and go, dude, assert attorney-client privilege. Don't talk about this. Assert client attorney privilege. Oh, God. This ain't good.
I really appreciate Ms. Lewis's help, but I did intend to claim the privilege. But I wanted to explain, because I've been in front of the whole world accused of mail fraud, which is outrageous statement. And I will tell the court, as an officer of the court, we have expended over $100,000 as of the day of that letter. And the insinuations and accusations by Mr. Bailey are outrageous, and I resent those. But we do claim the privilege.
All right, and do you want to explain to me how it is that you feel expenses and expenditures on behalf of a pro bono client fall within the privilege?
Exactly. If you're handling it pro bono, you don't bill for anything. You're doing it for free. I mean, normally it'd be like filing costs would be not considered part of the pro bono. But the actual out-of-pocket expenses for paralegals, your legal fees, your hourly fees, that's not good. So that's the whole point. If he's doing that, hey, Cool Frog, what's up? Cool Frog. If you don't know Cool Frog, make sure you go to Cool Frog. That's KOOLFROOG. He's the OG. He got booted by YouTube. He's one of the few, the proud, the people that fought back against YouTube and won and had his channel reinstated yesterday, I believe. Cool Frog won his appeal against a YouTube strike ban. He is back in action. Make sure you check him out. Make sure you subscribe to him. Cool Frog is the man. He the boss. His channel has been reinstated by YouTube. Congratulations, Cool Frog. You rock. And now, back to your regularly scheduled program.
The services rendered, whether they're pro bono or they're for a fee, in the description of services are certainly privileged. What we checked into with respect to the outrageous character assassination that the detective has been subjected to in the last 9 months and the work that we've done is definitely privileged. And our preparation in connection with potential defamation suits is privileged.
All right, thank you, sir. Mr. Bailey, do you wish to respond to that claim of privilege?
I certainly do, Your Honor. It
Oh,
appears
double
that
G.
the letter is in fact fraudulent. We're now told that
Hey,
it's
it's
to
rum and
cover
coke night
fees.
here, so.
The plain language, which every lawyer understands as unequivocal, is out-of-pocket costs have exceeded $100,000.
Yep.
Now, we're pro bono, we're covering fees, and we're out of pocket. None of this letter apparently is true in total.
Exactly. That's what I was saying before I forgot and talked about Cool Frog. You're handling it pro bono means you're not billing anything. But then to say you've experienced you've had these expenses and they need to be covered, that means you're not pro bono. Pick it, bro. You can't have it both ways. You can't say we're pro bono and then also be asking for fees.
But as it relates to the witness, this office, if they're acting pro bono on the one hand, nonetheless purport to represent him in a money damages claim for defamation to be brought when this case concludes and not before, based on correspondence we've received on behalf of Detective Furman. I've seen nothing to suggest that the $100,000, whatever it was, if it was, is segregated out as for representing Mr. Furman as a witness. And I contend that this letter says that they're representing him as a witness and in fact have won two important victories that relate to rulings you made relating to military records and his LAPD personnel records. We also
Yes, he had his military records excluded from evidence because they didn't want people to see that he had been disciplined as a I believe he was an MP in the Marines for potentially racist behavior, allegedly.
know, and we don't know of any contingent agreement, that lawsuits are being prepared because counsel says they're being prepared and the witness, more importantly, says that they're being prepared.
Oh yeah, that's bullshit.
How much of this money
Lawyers that nickel and
to be
dime you and
received
charge
from
you
the
10,
solicitation
20 cents a copy,
is
they
applied
suck.
to the lawsuit, where normally the client pays the costs, even in a contingent fee arrangement, is not
Exactly.
specified. But I think it a fair avenue of inquiry. And I think the test is, if the 100,000 comes in, does any of that inure Mark Furman's benefit? And did he expect it to when the letter went out? And is it not solely because of his position as a witness in this case that the solicitation was made with the hope of it being successful? If the answers to those questions are yes, I think waiver is patent in this case. When you go out representing to people through the United States mails that you've spent $100,000 on experts, investigators, and paralegals, an ongoing expense, that's a pretty serious allegation. And it is supposed to be, under federal law, completely truthful. I still doubt whether or not out of pocket went that high at any time prior to September 21, but I don't know. Ms. Clark alleges that she knows and assures the court that it did. I would like the opportunity to ask Mark Furman if any accounting has been given to him as against future obligations he may have in these civil lawsuits, or as against any fees that may have been charged, because we just heard that fees were included, by the Tortolo firm, and what he understands his position to be vis-a-vis the successful production of money from the police officers who are being asked to give it, like Daniel Lobato and the people in Oklahoma. That's what I think the cross-examination should be allowed to touch.
Your Honor, I have not represented Detective Furman as a witness. I've never discussed his testimony ever.
Dude, don't get into it with F. Lee
Officer of the
Bailey. You
court.
can't win.
I haven't been present at any meetings, and I have had no conversations with Detective Furman regarding the facts of the case, purposely. My representation has been as a result of the incredible character assassination campaign that commenced in July with the New Yorker article. And that's it. And to say that part of our work, the assumption Mr. Bailey makes, had to do with preparing him as a witness is ludicrous. Again, I represent to you as an officer of the court, I have never discussed Detective Furman's testimony with him, nor have I discussed the facts of the case with him.
All right, well, the factual issue, Mr. Tortolo, though, that I need to resolve is whether anything, any of the funds that were anticipated or received in response to this letter of September the 21st, and I take it this was a mass mailing, whether
There were like 425 or something. I don't know how many there were. We got very little money. But I do want to say this. I represented him as a police officer, and under the Constitution of the state of California, a police officer has a right of privacy, and it's a separate right. And he has the right to have a private attorney come into court and defend his rights of privacy, which is what I did before you.
Mr. Tortolo, before you launch into that, let me just ask, let me finish the question to you that I was trying to ask.
I guess there's been a lot of those problems in this courtroom. So,
Yeah, it seems that way.
Don't backtalk the damn lawyer, you idiot.
Mr. Torlow, the question I have is whether or not any of the funds that were generated or anticipated to be generated by this letter, did any of these go to the direct benefit of Detective Furman?
Absolutely none.
Can you explain to me how
Happy
that is?
Thanksgiving.
Because it goes to my benefit. I'm the one that's out the legal fees. I'm the one that's out paying my associates and my paralegals and my secretaries. Mr. Furman is not obligated to pay.
So why
one
is it
penny.
going out in Mark Furman's
Not one
name, you
cent.
fucktard?
Therefore, the benefit is to me.
If the benefit's to
doing
you,
this
send it
work
out in
and
your
to
own
my partner,
name.
Lori Butler, and to our firm.
Don't send
No
it out in
benefit
Mark
to
Furman's
Detective
name if he
Furman.
gets no benefit
Detective
from it.
Furman, well, whatever happens to this case, is not going to owe a penny to us. I'm doing it pro bono.
Pro bono, but asking for fees?
Any other
Figure the
comments,
fuck
Doug?
out what you're talking about, dude. Get out of here. Go away.
Is that it?
I claim the privilege and I'm ready to leave if you.
I'm ready to leave with you.
In fact, I'll catch the next plane to Hawaii if I could get someone to go with me. They'd love it. His comment was, please do, but
No, I said it was a good idea.
Yeah.
So thank you.
I'm sure he does.
All right, well, today's been a pretty contentious day. All right, any other comment from the parties? Mr. Bailey, Ms. Clark?
What do I do every time I watch this?
Certainly.
Start yelling at people? What? What do I do every time I watch this?
I think that eventually, I know loath as a defense is to let any detective off the witness stand, at some point, we have to. And if we get into this letter, this is going to be another, look at what it just does now. Just to claim a privilege, just to argue the issue.
Well, we were lucky
Spend-
Mr. Tortolo was in the building.
We were, and we are, but.
No, the
this
jury's
one
not here
needs
right
to
now.
alone. The consumption of time to go to an issue that is basically a privilege matter, because the heart of it is a privilege matter.
It wasn't privileged until that lawyer stood up there and said it was privileged. This was necessary. Shut up, Marcia.
His lawyer hopes to be made whole by it because he has expended so much time and effort on his behalf with no recompense. And that's all you have here.
He took
So
it pro
bias and
bono.
motive issue,
If you don't
which is
want to
what
be out
it
of
should be going
pocket,
to,
don't take
is
it pro
non-existent.
bono.
So the letter is really and truly irrelevant in addition to being privileged.
All right. Mr. Bailey, any last comment after Mr. Tortolo's comments?
Well, I think I've expressed, Your Honor, the fact that even if nothing more, Mr. Furman is getting a free lawyer, if he is. And to me, that's very cloudy by virtue of this solicitation,
Mm-hmm.
where he would not have gotten a free lawyer perhaps if he hadn't authorized the solicitation.
Is it
That
free
is
or
a
not?
Financial benefit sufficient to warrant cross-examination.
But he had the free lawyer long before.
Thank you, counsel.
But is it free if the lawyer's asking
issue
for money?
of cross-examination and the extent of cross-examination is something that thankfully the appellate courts have rested significant discretion in the hands of the trial court. And in some areas, when we deal with, say, for
She gets a
example,
serious
racial
mid-trial
bias,
makeover.
the courts have indicated that I must give either side wide latitude in cross-examination on racial bias and those issues, and the court has done that. This is an issue of financial bias, and given the representations of Mr. Tortolo, the financial interest of Detective Furman with regards to this particular letter is remote, and I find it not to be relevant. Were it to be relevant, it would cause an undue consumption of time, given the various issues that are here, and the claim of privilege also goes to the heart of the letter. So the prosecution objection will be sustained.
All right. So the letter doesn't get to go in after all of that.
By Mr. Bailey yesterday, in advance of our having been given the opportunity to see this letter be stricken from the record.
No, he was
Right back.
allowed to cross-examine on whether or not Mr. Furman contemplated legal action against the lawyers in this case. That's fair cross-examination.
Right, no, but he also asked about the letter. That's what I'm asking to be stricken.
I think there's only, if you can show me where that is in the record, I think there's only a question or answer that's pretty innocuous, and we stopped at that point with the purpose of getting the letter to examine it.
All right, maybe I readdress that with the court after I found the passage. If that's the case, then there is no point. But
I have to tell you, my recollection of it is that it's so innocuous that I'm not really inclined to stir the pot anymore.
Very well, Your Honor. What I'm concerned about is final argument, though, and addressing an issue that the court has deemed to be irrelevant under 352.
Well, if there's no letter to argue, then I suspect it won't be argued. Given the panoply of issues that are here to argue in final argument, a passing reference in 2 questions and 2 answers, I suspect won't carry the case. If you disagree, look in the record, see what you think. I'm just not inclined to address what I consider to be such a minimal issue at this point. Maybe if I think about it tomorrow morning, maybe I'll think about it differently, but I got to tell you at this point, I'm not real persuaded.
All right, let me look it up and see if it is worth it. I appreciate it.
Okay.
May I learn, Your Honor, whether this is anyway identified for the record?
It should be. The clean copy will be identified as Court's Exhibit next in order 8.
May I be excused, Your Honor?
Yes. Thank you, sir.
All right, we're coming to the end of March 15th, 1995.
Do you have anything else you wish?
3 o'clock, Your Honor, I'd like a chance to, we have information coming in as we speak. I'd like a chance to confer with my colleagues before we decide.
All right.
The only remaining questions. I have a question I can put today. If you want to save that much time, it's about 3 minutes worth.
Not to drag the jury out and then send everybody home. All right, Deputy Mayor, let's have the jury. I'll excuse them.
All right, so there he just brings the jury back and sends them home for the day. All right, we've finished that day's testimony. There's just a little bit more of Mark Fuhrman to go. But before Mark Fuhrman's final few questions on cross-examination, they got to do a bunch of stuff outside the presence of the jury related to the fight that Marcia Clark and F. Lee Bailey had the previous day. Before we get into that, let's just hit some super chats and some other comments that I found mildly amusing. And while I'm reading those, just note we have 437 concurrent viewers and 297 likes. We should be up to about 400 likes by now. So I would greatly appreciate it if all of you would give me a little bit of consideration and reach down there and hit that like button. I know you don't think about it. You're just watching, you're being entertained, you're going about your business, whatever. But we creators, we care about the likes. We focus on the likes because that's what YouTube focuses on. The more likes, the more they get the news about the channel out. So please do me that favor and get down there and hit that like. And I want to thank you guys, like the regular viewers, the new viewers, whoever. I really want to thank you from the bottom of my heart. We have, because of you, we have epic viewer to like ratios. We have some of the highest there are in YouTube because you guys, almost to a person, hit that like button. And I deeply, deeply appreciate that. So I never take for even your likes. I never take them for granted. I never take the super chats for granted, of course. I never take just the likes for granted either, because it means so much to me and it gets the word out on YouTube. And hit that like button. Don't forget to hit that subscribe button if you haven't. And if you have already subscribed, just make sure you're still subscribed. YouTube kind of unsubscribes random people randomly for random reasons. That out of the way, let's read some super chats, and then we'll get back into the testimony. Haas Knuckles says, morning vices. Happy Thanksgiving. Well, happy Thanksgiving to everybody out there. And thank you so much, Haas, for that. Deeply, deeply appreciated. Floppy X Turtle, long time no see. How you doing? Thank you so much for that Thanksgiving super chat. Good morning and happy Thanksgiving. May the food comas be plentiful. My food coma is deferred until Saturday. I made my best effort to get at least a turkey sandwich from Subway today. Failed miserably. Got a sliced chicken, bacon, and oh, what the hell was that? Okay, sorry, my screen just glitched. Got a chicken, bacon, and avocado Subway sandwich. in his place. But Saturday will be my food coma. Thank you so much for that. Ivy Cowboy says, Legal Vice says, they really were masterful lawyers. A few of them were, yes. F. Lee Bailey, as I've said repeatedly, is one of the most effective, one of the most brilliant, one of the best defense lawyers ever to set foot on planet Earth. The next lawyer we're going to look at, Barry Scheck, is an amazing master of cross-examination on evidence gathering techniques and whatnot. And Johnny Cochran, not the best legal mind in the world, but dude has flash, showmanship, and likability. So he's one of the most charismatic lawyers you'll see. So those three are awesome guys. No questions. And Lisa M., I'm still confused about OnlyFans. Is it porn? Yeah. Short answer, yeah. Holy shnikes. Feel like Bailey could have read for Unsolved Mysteries. That's something every week we've done F. Lee Bailey. People have mentioned that he sounds like Robert Stacks quite a bit. Was it Robert Stack or Robert Stacks? Robert Stack. Yeah, Robert Stack. He sounds like Robert Stack quite a bit. We get that every week. So you're not alone. You are not alone. Gypsy Soul. I love Bailey's old American accent. Well, that's one thing that's interesting. As I said, I was going to show some interviews of F. Lee Bailey and things once we wrap up his just murdering of Mark Fuhrman on the stand. One of the interviews we're going to watch is an old firing line interview with F. Lee Bailey when he was in his 30s, being interviewed by William F. Buckley Jr. And I mean, talk about old school American accents. You got F. Lee Bailey doing his semi-Massachusetts thing, but on top of that, you've got the William F. Buckley doing his total Boston Brahmin pseudo English accent there. The old school Boston Brahmin money from William F. Buckley Jr. Yeah, oh yeah, we'll definitely get into the William F. Buckley Jr. lockjaw. But yeah, some of those good old American accents we'll get into with F. Lee Bailey and William F. Buckley Jr. Oh wait, there we go. Steve Acre says pro bono doesn't eliminate costs involved. It usually, it does eliminate office costs involved, usually not court costs. So if there's like $100 filing fee, usually the person would have to front the filing fees, but office costs, office expenses, mailing costs, all that other stuff is usually included in the pro bono thing. What's with the hourglass collection? Asks A Job Done Well. That was a thing that at the beginning he had an hourglass. People queued into that, and it became known that he liked hourglasses, so people started sending him hourglasses, and that's kind of one of the ways he sort of fell for the glamour of the media and started playing for cameras and things. He was a great judge as it started, when this case started out. By the end, he was playing for the cameras, going for the showmanship, and had really dropped off insofar as quality of a judge is concerned. This is just one of the and as a matter of fact, we're in just in about 20 minutes from now, we're going to get into a weird thing where he wishes somebody watching in the gallery a happy birthday. I mean, it's just weird. But yeah, people found out that he liked hourglasses, and they started sending hourglasses, and he started putting them on his desk in front of the camera, which is just weird. As the William F. Buckley, villain of the new right. We'll get into him next week or the week after. And one thing I noted yesterday, because it was repeatedly jammed down my throat, I've been saying circuit, craft, and crime since he started being here. My mama just saved my week by sending me $50 unexpectedly. I was afraid of going into overdraft this week, but I do owe an apology, because it's cricket, crafts, and crime. I'd been saying circuit, crafts, and crime this entire time because I'm an idiot. So cricket, crafts, and crime. Howdy. How you doing? Jeff, thank you for letting me know that I'm not alone in having music lyrics scamper in my head 24/7. No, I do. That's one of my weaknesses, just random song. Oh, hey, what's up, Yoda? There's Yoda over there, back there. Yoda, what's up? Yoda. Damn it. I hate these reverse cameras. What's up, doggo?
Hey, hey, buddy. What's up?
Yoda woke up and came and paid me a visit. All right. With that, we're going to go to the next day of hearings. And but before we go to the next day hearings, we have to go back in time to this dispute I was talking about a little bit earlier between Marcia Clark and F. Lee Bailey. F. Lee Bailey, they were looking to bring a witness in, Mr. Cordoba, to testify that when he was at a Marine recruiting station a few years before this happened, he heard Mark Fuhrman use incredibly racist language. And the defense investigator called him, talked to him, and this guy was a Marine. F. Lee Bailey was a Marine, and coincidentally, Mark Fuhrman was also a Marine. So you got to remember, this is 1995. This is only 20 years removed from Vietnam. So a lot of the people were service members that had served in Vietnam. So there was a lot of military people. So F. Lee Bailey said that he talked to Mr. Cordoba and talked to him Marine to Marine and just said, thank you for coming forward. To come and testify about this takes courage, whatever. But Dateline NBC apparently called Mr. Cordoba and said, did you talk to F. Lee Bailey? And he said, who? No, never talked to him before. Marcia Clark jumped on F. Lee Bailey's shit, saying he lied to the court. He's misrepresenting facts to the court. This never happened. He's a liar. And F. Lee Bailey gets pissed. And then he says, if you want to know what happened, put Cordoba on the stand and ask him if I ever talked to him. And we're going to go back and we're going to revisit that because it directly plays into how the next day of the hearing starts. And so we'll just burn through about 15 or 20 minutes of this back argument they had, and then we'll catch up with the court in real time. Oh, hey, Strawberry. Strawberry's admiring the Godzilla poster there. Dargy. Say hi to the camera, Dargy. Dargy is Strawberry in Korean. All right. Anyway, there's the doggos. So let's go back, watch this dispute again. Those of you that saw this a couple of weeks ago, it'll be familiar to you because we already watched it. For those of you that haven't seen it before, you'll get to watch probably the most aggressive argument between Marcia Clark and the defense that took place during the hearings. But before we do that, we have Kendra Kate. It's my birthday on Sunday, so I didn't want to miss an opportunity to tell a stranger happy birthday. Whose birthday is it here? Just tell anybody if it's your birthday here in the chat. Happy birthday to you from Kendra Kate. But Kendra Kate, if you're not here, if we don't see you before then, happy birthday to you on Sunday. You rock. And here's to another turn around the sun. Right. Back to the F. Lee Bailey issue. Share the screen. This is the argument that took place earlier on in the day we just watched, but for us here in YouTube time, it was 2 weeks ago, maybe 3 weeks ago. And this is how it went down in court.
There is, Your Honor, partly because I personally represented to you yesterday that I had spoken with Max Cordoba, because you may have heard reports that he gave a conflicting statement. I want the court to be reassured that I did indeed, about 2 weeks ago on a weekend, from Mr. Cochran's office, call or talk to Mr. Cordoba. Mr. McKenna was talking to him and interviewing. He called us. McKenna recognized his voice. They had spoken before. He handed me the phone just to say hello. As one Marine.
Yeah, I talked to my dogs in Korean.
And handed the phone back. We reached Mr. Cordoba last night, and he said, yes, that's correct. I was confused when the fellow asked me the question. But the disturbing thing is that NBC would air that statement nationwide without picking up the phone to call either myself or Mr. McKenna, whom they're perfectly able to hound when they want something. They know where we are at all the time. They could have avoided this whole mistake. And that level of journalism is sinking way below what one expects of NBC. And I'm very upset about it. And I have reported it to
So again, his explanation is he said that to Dateline NBC, but we talked to him and he remembered that he had spoken to me and whatnot. It's kind of a convoluted thing, but they hash it out over the next 15 minutes. So I won't interrupt you too much. We'll kind of let it flow as much as possible. Someone asked how far along in the trial we are. Okay, yeah, there we are. It was Jeff Gann. How far along in the trial were we at this point, Jeff? This is March 15th. So we're like a month into the trial at this point. June, July, August. Well, I guess we're about halfway through the trial. Sorry, we're about 4 months into the trial. This is kind of midway-ish. So not too well. In the whole grand scheme of things, we're about midway, but we're well into it, but we're still far away from the end. So let's get back into this. Tensions are running high. There may be a little sexual tension here between Marcia Clark and F. Lee Bailey. All right, let's get back into it. We'll try not to interrupt it too much. We'll only interrupt for super chats and if I feel a need to rant.
Dateline, and I'm expecting a correction this evening when the matter is pursued. More to the point of this trial, Your Honor, you had ruled out the testimony of Mr. Coleman, who runs the...
We don't need to watch this part.
In the horrendous event that should ever become necessary, I'm asking that you give me the opportunity to put Mr. Coleman on...
We don't care about Mr. Coleman.
Corroborates Max Cordova, because after Detective Furman called him a nigger inside the building and followed him out to the parking lot and did it again.
Incoming
Cordova
N-bombs.
came to Coleman's place of business. Coleman remembers the incident and said, I had to calm him down. He was very upset and he was very excited by the whole thing. Now,
Well, that's a different offer of proof.
I understand it. I'm bringing that to your attention because I learned it a short time ago when I called to see if Mr. Coleman would be available to come down and make an offer of proof on the record. That to me is...
Okay, real quick here, history lesson for those of you that haven't heard this. I've told this about 112 times, but some of you may not have heard this. The reason why he was not hesitating with the hard R was this trial, this cross-examination you're witnessing of Mark Fuhrman right now is the reason we say the N-word today rather than just dropping the N-bomb with the hard R on the end. This case was the reason that today we say N-word, was because Mark Fuhrman was on tape dropping hard R N-bombs. F. Lee Bailey was sticking the N-word to him, dropping the hard R N-bombs, and the black prosecutor, Christopher Darden, was refusing to say the N-word. So rather than saying the N-word, then you're dropping the N-bomb, he would say the N-word. So this OJ Simpson trial, specifically this cross-examination of Mark Fuhrman, is why today we just refer to it as the N-word instead of dropping the hard R. So that's a little bit of a cultural history lesson for you for those of you that may not have known. This cross-examination by F. Lee Bailey of Mark Fuhrman is where the term N-word was birthed and became popularized. Back into it.
Is the best possible form, and we think it would be worth the court's time to preserve it.
How about a statement in writing? I don't want to take up the court's time doing extraneous hearings all the time, counsel.
All right. Now, if you can enable me to understand, Your Honor, you have a rather elaborate statement on the first part. Cordova, it seems to me, is a separate issue entirely.
I agree.
And his testimony would be relevant if Cordova testifies, as he told Dateline he would last night, and is attacked on the ground that he made the incident up. Other than that, I'm not sure that a prior consistent statement would be admissible, but should it be termed a recent fabrication on Cordova's part, and that's the drift I get from this side of the table, then the fact that he said that to Coleman hard on the heels, even if it's not part of the res gestae, would become admissible under California law. I don't think that question is going to be presented to you as to the Cordova part. unless and until that attack is made. I do think that I would like a better form, and if you're suggesting I rewrite or we put together a new, more formal statement, since those were all Mr. Coleman's words, pinpointing the issue that we wish you to take another look at, perhaps. I'll be happy
Patty,
to
that'll
do
get you
that rather than
banned.
take up the
Don't
court's
do it.
time putting facts. Beyond that, Your Honor, the phones are ringing and ringing hard. People calling in who watched the detective and now wish to offer
Patty,
evidence.
it's not worth it.
Did Mr. Bailey make a direct misrepresentation to the court yesterday? He's done it again this morning. And I think that as I said yesterday, as I predicted, the tape would be very illuminating.
Good,
and
Patty.
provide the court with some very graphic evidence of the way counsel takes his role as an officer of the court so lightly. I want to play this tape now so that the court will be reminded of exactly and precisely the language Mr. Bailey used yesterday when he sought to misinform and mislead this court as to the nature of his contact with Mr. Cordova.
All right, Ms. Clark, what is this a tape recording of?
I'm sorry?
What is this a tape recording of?
His appearance in court yesterday, in which he stated to this court, in which he stated to this court that he had a conversation, Marine to Marine, with Mr. Cordova, and that Mr. Cordova told him, not Mr. McKenna, him, the statements that he later reported to this court.
You're referring to the comments by Mr. Bailey at 18606, beginning at line 15.
We don't have a transcript, Your Honor.
We don't either.
Yes, you do.
Recovered alcoholic member for 1 month of clean and sober says Tank Rat is love. Tank Rat is
18606,
life.
starting at
Happy
line
Thanksgiving to you, Korea. If you care, I care. Just past 3 years sober. I now drink through you and Nick drink up. Congratulations for being 3 years sober. That is a huge
Okay.
accomplishment.
Mr. Cochran.
Mr. Darden and Ms. Lewis about this incident, and they shut him off. They said, we're only interested in what Ms. Bell said. And that's what he will testify to. And Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest.
So this is the beginning of this. This is what they said the previous day at the court. I've spoken with him, whatever. Copper Grasshopper, that wasn't the mods, that was me. that was me. I warned him not to finish the NI spelling. He finished it. I had no choice because, as I said, we don't ban things, we don't block things. There's only one rule: nothing that could possibly get me deplatformed, and that's one thing that could possibly get me deplatformed. Patty took the risk after being repeatedly warned not to finish that word, and he finished the word. So it's not a power trip, it's a channel preservation trip. This isn't locals, this isn't Rumble, this is still YouTube. That's like the one thing I will not put up with is people joking around and having fun and saying dumb shit that can get me deplatformed. So yeah, Patty, no. The Nigerian only has one G. Come on. So there you go. Welcome back. Just don't do it. That's all. Enough said. Let's move on. So they're playing back his statement where he said that I talked to this guy, Marine to Marine. He said this, I said that. And then Marcia Clark is going to call him a liar and shit's going to go off the rails.
Ms. Lewis about this incident, and they shut him off. They said, we're only interested in what Ms. Bell said. And that's what he will testify to. And Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever. As far as discovery is concerned, there is no written statement. There are no notes that I know of. And I heard about this because he called us wanting to make it known that these people had tried to suppress this information. I spoke to him personally. I don't ever take notes, and I didn't on that occasion.
All right.
And that's a smart thing for a lawyer, never to
Not
take
what
notes.
Clark says, I said, I did not claim that he related the incident to
He
me.
did
I said, I spoke to him and I
spelling.
have no doubt that he'll appear. And I don't have any doubt.
All right, why
This
don't
is
you
the
let-
kind of nonsense that gives
Wait.
lawyers a bad name, Your Honor. You know, it's very clear what he said to the court and what he was intending to convey. He was intending to convey to the court that he had personal knowledge of what this man said because this man said it to him personally, Marine to Marine. And now he's standing up and hair splitting with us. I never said he said this to me. I just said he spoke to me personally. That's nonsense. That shows you what we have over here in the way of ethics on this side of the table. They'll get up and they'll misrepresent to their heart's content until they get caught. And then they have excuses. And then they start splitting hairs. And then they have, well, this means this. And oh, no, that means that. I feel like we're in Alice in Wonderland. We've got Jabberwocky here. Nothing means what it says it does. No means I don't remember. I don't remember means no. Same thing. Now it's coming out of the mouth of Mr. Bailey. But that's exactly what we can expect to happen when the witnesses take the stand. If we rely on his offers. And we have not been able to reach Mr. Cordoba, we need to talk to this man personally. I can assure the court, absolutely. No one cut Mr. Cordoba off. No one refused to listen to him. As a matter of fact, Mr. Darden kept it, tell us more, tell us more. Please, is that all you have? Is there anything else you want to tell us? And with respect to Mr. Cordoba's prior statements, they've been aired on national television. I mean, if Mr. Bailey doesn't know what he's said before, I guess he's never turned on his television set. But they're a matter of record that all the world has seen. So if he is now claiming to have heard something as volatile and inflammatory as what Mr. Bailey is representing, we do have some serious impeachment. But no one cut that man off. We did not have the opportunity to speak to him, so we do not know exactly what he has what he's going to say at this point. I certainly do not feel comfortable accepting anything that Mr. Bailey offers to this court, especially in view of what we've heard. And I would like to play the clip for the court from Mr. Cordoba, because Mr. Cordoba, when given the opportunity to say, I spoke with a member of the defense team, I spoke with an investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Bailey,
The Chrysler
you can see
Cordoba.
how agitated he is, has been caught in a
Corinthian
lie.
leather seats. Nice,
And
nice
you know
old
something, not in this case,
Chrysler
you don't get away with
Cordoba
that.
blast there.
There's just too many people watching.
Cheers, chosen one.
I object to the lack of.
Here we go.
the
I was
kind.
talking over
And I
some
think-
very important things. This is where you have incontrovertible proof that the prosecution is playing to the cameras. They're playing to public opinion. She absolutely flat out admits that they are conscious of and playing to the camera. Was OJ Simpson in custody throughout the trial? Yes. And so listen to her. Listen to what she says to show that what she is saying is in a lot of ways done for the media watching this.
Investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Bailey, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
Right there. He wants to get away with a lie. He's not going to do that because there are too many people watching. Right there. She is saying this is being broadcast to the world. The world is watching. So he can't get away with these lies. That says right there, the prosecution is playing for the cameras.
I object to the lack of foundation for this tape. Excuse me, don't play the tape while there's an objection. If Ms.
Bailey's
Clark is
pissed.
going to take the stand and authenticate the tape, let her do it. But tapes are not self-authenticating. We've had no chance to see it, as you always require, before we're allowed to show anything to you. And I'd like to know where it came
Not
from and what
before
it
you-
represents.
Not before you can show it to me, before you can show it to the jury.
Right.
All right, Ms.
I'm
Clark,
just
what
showing
is
you to
this?
the court, if you please, Your Honor. It's self-authenticating. The man on it says he's Max Cordova.
Well, no, we've gone through the self-authenticating argument before, which I did not accept, if you recall. But being that as it may, what is this?
This is the tape of an interview with Dateline, which was conducted yesterday after Mr. Bailey made his representations that he had spoken to Max Cordova. After he made those representations in court, Dateline went and interviewed Max Cordova and asked if he had had an interview with Mr. Bailey, Marine to Marine. And Mr. Cordova said, no, I did not.
Which answer is correct?
All right. Do you have an extra copy, by the way?
He's got a new partner to solve this mystery.
That's Bill.
That's Bill Cosby.
That's Bill Cosby, Ms. Clark.
I'm aware of that, Your Honor. We're not offering Bill Cosby at this time.
Bill Cosby doesn't age well, does
Your Honor,
he?
if I may request that the notes Mr. McKenna surely must have taken as a responsible investigator of that interview that we now learn occurred, which obviously Mr. Bailey did not want us to know yesterday. We want the notes of Mr. McKenna's interview with Mr. Cordova yesterday.
No, Sean.
See, F. Lee Bailey's smart. Never take notes,
It's
man.
interesting that other states have.
See, F. Lee Bailey is smart when he says he never takes notes of interviews, because if you don't take notes, they can never be subpoenaed by the other side. You can never be forced to turn over notes you never took. That is a lesson for all.
Rules of reciprocal discovery that require at least some offer or indication of anticipated testimony in their reciprocal discovery statutes, which is something California does not have.
I find it interesting, though, that it would appear the investigators for the defense in this case have prepared reports and taken notes on all other witnesses, but surprisingly, nothing on this one.
Well, I assume that's something you'll cross-examine on.
Probably fair to assume. Well, at least Mr. McKenna, a witness at the very least.
And Ms. Clark, who tape recorded this for you?
Excuse me? Media Relations Department did, Your Honor. After contacting Dateline to find out when the interview was conducted.
And are you representing to the court that this is a videotape of the Dateline broadcast when?
Last night, Your Honor. This is a videotape of the Dateline broadcast last night, an interview that was conducted with Max Cordova after Mr. Bailey's representations to this court yesterday concerning his contact with Mr. Cordova.
Bill Cosby drugged OJ so he was busy during the murders.
That he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever.
No, I have not talked to F. Lee Bailey.
If you believe Max Cordova, and the defense hopes you will, then Simpson's defense team has some explaining to do. Because today, in our exclusive interview, the ex-Marine and potential witness said he didn't know what F. Lee Bailey was talking about. That if he'd spoken to the famous attorney, he'd remember, and he doesn't. Never talked to him.
No.
You know who F. Lee Bailey is?
Yes.
Pretty distinct fellow.
Yeah.
Pretty distinct voice.
Correct.
So you haven't talked Marine to Marine to F. Lee Bailey?
No.
But Cordova told us he does remember talking to Furman, and what he now says Furman told him ignited a heated debate today in the courtroom.
Max Cordova wanted to tell Mr. Darden and Miss Lewis about this incident, and they shut him off.
By the way, that representation will be disproven as well.
That was a telephone in the early days of cell phones. That phone must have been like this big. So anyway, we've got this video that purportedly say F. Lee Bailey said, I talked to this guy Marine to Marine and thanked him for coming forward and whatnot. And now you have the guy saying, I never talked to F. Lee Bailey. I know who he is. He has a distinctive voice. I never talked to him. That is the crux of this argument here.
Now, Mr. Cordova had the opportunity to say, well, yes, I had some brief conversation with Mr. Bailey, but we didn't discuss the content of my testimony. Or yes, we had a brief contact. He said hello to me. Mr. Cordova said none of the above. He had the opportunity as well to say, Mr. McKenna spoke with me. I know he's a defense investigator. He did not say that either.
All right, Ms. Clark, let's assume for the sake of the argument that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Bailey should be cited for contempt and fined substantially. As an officer, an officer of the court, he has lied to this court. He is impeached by his own
Your Honor, and I ask
witness.
that you put a stop to it. Either
Mr.
put
Bailey.
Cordova on the
Excuse
stand
me, Mr.
or
Bailey.
stop her from
Mr.
getting
Stand
Bailey.
up and speak when it's your turn.
Mr. Bailey, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordova makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Bailey got up to represent to the court this morning. Mr. Cordova was confronted with the statement that Mr. Bailey made, that they spoke. He said, no, we did not. And I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
All right, thank you, Ms. Clark. Mr. Bailey, do you wish to respond?
Of course he does.
Your Honor, and I do not appreciate being called a liar in any court, and I will ask at the proper time for correct action to be taken against the offender. The proper way to proceed, if there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence. What they eliminated from the tape that I saw on NBC News this morning was that Stone Phillips said, why didn't you mention these things before? He said, I only give very narrow answers to every question. As he explained to Mr. McKenna last night, he did not have an interview with me, nor did he tell me his story. When he was talking with Mr. McKenna in the office, Mr. McKenna handed me the phone to introduce me. And I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know that it's painful. And he said, I'm willing to do it. And my comment to the court was in response only to the unfounded, irresponsible, and false assertion by Ms. Clark that Cordova would never appear. She had no basis to say that whatsoever, as she has just shown with her own videotape. Now, I expect NBC to correct it, and somewhere down the line, I hope that this court record is made plain. Mr. McKenna is sitting right here, and he is available to get on the witness stand and assure the court that Max Cordova said last night, okay, I now remember I spoke briefly on the phone. That's not an interview. Phillips could have saved himself some embarrassment if he'd bothered to pick up the phone and call me. NBC always finds me when they want to.
I am
All right, so that is the argument that they had. And how does it turn out? Well, it turns out, as we will see here in just a minute, that Mr. Cordova misremembered when being interviewed by Dateline. And he admitted to actually having this brief conversation with F. Lee Bailey. So Marsha Clark was completely in the wrong here as it came out. And that's where we pick up the next day's testimony from, which we'll watch here for a little bit. I desperately want to see if we can get through Mark Fuhrman testifying today. Let's see how much we have left. I'm kind of scanning through here. Okay, we can get through Mark Fuhrman today. No problemos. But before we do that, before we jump back in, let's hit a couple super chats and a few comments that I wanted to get to. Haas Knuckles says, Jeff, you missed my whiskey suggestion. I did. So I went back and I found it. I apologize for that. Haas Knuckles also said whiskey suggestion. Aberlour Speyside single malt 12-year double cask matured, super delicious. And I'll have a glass for you, buddy. That is a solid whiskey. The Aberlour 12-year is great. I don't have any of my drink. That's my Aberlour 15, and behind that is my Aberlour Abuna. But I drank my 12-year and my 16-year, I believe it was. I'm not sure if they make it. Whatever their duty-free one is, I drank it. But I've got the Aberlour 15 and the Abuna left. So yeah, Aberlour makes a great sherry cask matured whiskey. Can't go wrong with it. And Britt Cormier just coming in. I like how they allowed a VHS tape of an interview with a news agency into the court when the news was trusted to not shade the record. Interesting to see how far we've come in our trust. Exactly. Now the news is not about reporting the news. It's about making the news or being part of the news. All right, now just a couple of other things I highlighted that I thought were interesting and wanted to get to when there was time. KS says, and Helene, don't mean to butt in, but I liked your question. What was Helene's question? We'll get back to the rest of that there. A recovered alcoholic, I think it's a huge thing. You can watch them. Isn't that triggering at all? Sorry if it's a too personal question. If so, just ignored it, and sorry for that. So back to KS. I'm 17 years sober, and I have a line when creators are really drunk. I watch until I feel weird, triggered, and then shut it off. I mean, that's a line that whiskey drinking creators have. I mean, there's the point where you just become a drunken sot and make an embarrassment of yourself and whatnot. I try never to cross that line. I don't think I've crossed that line. If I have, I don't. I may tend to disagree with you. I've come close. I have kind of this thing. I don't get into the just stupid, ridiculous drunk thing. Once I start to sort of lose my capacity to process things clearly and rationally, I personally start feeling weird and bail out. Like once a month, we do the Fuck It Friday stream where we just grift for $100 shots and we make as much money as we possibly can on that day so we don't have to grift hard the rest of the month. This last month was the first time I had to tap out. November was the first time I had to tap out because I was like losing my senses. 26 shots in, I had to pull the plug because that was the end. I'd reached my limit. I think that's the point where YouTube creators who drink, and especially those of us that have our little grift drinking things, you've got to know how to control yourself. You've got to keep control of your faculties and know when to quit. And that's what I did. So I drank the 26 or 27 shots. I owed 15. I made up those 15. So, by the way, for those of you that care, next Friday, the 2nd of December, will be the December F It Friday stream. So stay tuned for that. We'll talk about law-related news while I grift for $100 shots. So mark your calendars. Next Friday is the Fuck It Friday drunk stream. We'll see how many we can get through before I have to tap out that time. Hopefully we'll see how many I can get through. That was the first time I had to tap out was this month because I agree with that. Thank you, KS, for your comments. That's one thing that I try to be cognizant of. I try not to get into that, ridiculous, just, liquored up, degenerate, just shit-faced, incomprehensible, drunken, lush thing that some people get into. That's not me. And I hope I don't trigger anybody. But if I do, feel free to walk away for a day if you're triggered by the drunk streams that I do on the Fuck It Friday. Those are really the only times I ever just kind of go overboard. Yeah, Joe Purim stream, that was wild. That was brilliant. Anyway, that's me. So Fuck It Friday is coming up a week from tomorrow. Enjoy it. We'll be there. And my Fuck It Friday rule is, we started this a couple of months ago. 25% of whatever I make on a stream will go to the next bottle of whiskey. And as you can see, I'm a whiskey connoisseur. I enjoy whiskey. I love the taste of whiskey. I respect whiskey. I think even Jack Daniels needs to be sipped and appreciated. But what I've done is 25% of whatever I make on a Fuck It Friday stream goes into the bottle for the next Fuck It Friday. And after YouTube took their usurious cut, I'm left with buying a $700 bottle of whiskey. And as I said before, I mean, last month was a $500 bottle of whiskey. That killed my soul a little bit to just plow through a bottle of 25-year-old Glenfarclas. This month, it's a $700 bottle of whiskey, which will be the most expensive whiskey I have ever purchased in my entire life. And it's going to crush my soul. Not a little bit. It's going to crush my soul hard to consume such a valuable, delicious whiskey in shots. That hurts me even to think about it. And for the record, the whiskey I'm thinking about is a limited edition 22-year-old St. Andrews Golf Open edition of Loch Lomond whiskey. There's only 4,000 bottles of that whiskey on planet Earth. And I'm scheduled to waste one of them a week from Friday. Shame on me. Shame on me. But I'll do it. So stay tuned for next Friday's Fuck It Friday to destroy a one of only 4,000 on planet Earth bottle of whiskey. So, all right, with that out of the way, let's jump back in. Oh, wait, I've still got a bunch of comments to go through here for. We did the Helene thing. We did the KS thing. And Cricket is back. Cricket Crafts and Crime. I'm very new to YouTube creator scene, and if you ever do Valo Daybell, I have lots of thoughts as a cult survivor and would be honored to join you on your stream if you do. Unfortunately, just this last week, the courts decided that the Valo Daybell trial will not be televised. So there will be no cameras in the courtroom for that trial. I will do updates regularly. And please be, if there's something that you feel like you could contribute on stream, let me know at that point in time. But it won't be a court trial. They won't televise the trial, but we can still do updates. And guitar boob, guitar and boobs are nice. Weren't you and Bailey blasting Furman for not taking notes? Yeah, that's different. The lawyer not taking notes is different than the one of the detectives investigating a crime not taking notes. His notes are going to be an integral part of a trial. They're going to be integral in forming his notes, in his reports. They're going to be integral in forming his testimony. But the defense lawyer's notes are between him and his client and have really no bearing on the trial, and it's best if they aren't kept. Where it's like the fewer notes a defense lawyer can take is better, and the more notes a investigator can take is better for the investigator. Alfred Sparman says, yes, finish today. I love this series. Oh, we're not going to finish the OJ Simpson series today. We're just going to finish the cross-examination of Mark Fuhrman. Next week, we'll get into the witnesses that are called to rebut Mark Fuhrman's testimony. Mark Fuhrman is still weeks from being done. Ha ha ha. Vince Clortho. What's wrong with rum? Sailors drink. Nothing's wrong with rum, especially if it's good rum. Lost and Found Mark F. commenting on Idaho murders is weird now. Yeah, we'll get into that on Tuesday. And again, Cricket Crafts and Crime. I live down the street where I was attacked twice during the 10 years of being in a cult there. I have to know how to control my triggers. Hopefully we won't get into anything culty triggering. Xcomer Triple Z, have you seen Jack Daniels suing that dog toy company, Bad Spaniel or something? No, I have no idea what that's about. I'll have to look into it. But all right, with that, let's jump into the next day of trial. And all of that stuff we just played, the rehashing of the fight between Marcia Clark and F. Lee Bailey, is picked up at the beginning of the next day trial. That's why we went over it. So you'd have some reference points for what you're about to see right now. Embiggen it. And I will be right back as soon as we get started.
With his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. And before we begin this morning's session, the court would like to take the personal opportunity to wish a happy birthday to Ruth Archie, who is one of our regular audience and on her birthday today. All right, counsel, is there anything we need to put on the record before we join with the jury again? Mr. Bailey.
Yesterday, there was a question raised as to whether or not I had spoken personally to a witness named Max Cordoba. And that question arose from a mistake Mr. Cordoba made when being questioned on Dateline. NBC yesterday at various times during the day and Dateline itself last night corrected that misstatement. They found Mr. Cordoba in Phoenix, and he recalled that briefly while Mr. McKenna was interviewing him about the facts of the case, that I had spoken with him about his.
Okay, so how is the court? Is the volume? Can you hear this? Because I can barely hear it. I don't know if you can hear it or not. But this is where F. Lee Bailey stands up, as you may have just heard, and said they got a hold of him, and he admitted to remembering speaking to me. This is where Marcia Clark got it all wrong yesterday when she was jumping on his shit. Okay, so people are saying you can barely hear it. So we'll boost the volume up here to about 300% and see how that goes. But other people are hearing it all fine. So some people say low, some people say fine, whatever. We'll bump it up a bit and get back to it.
Last night corrected that misstatement. They found Mr. Cordoba in Phoenix, and he recalled that briefly while Mr. McKenna was interviewing him about the facts of the case, that I had spoken with him about his appearance. And I would simply like, because the prior version is now a part of this case to a degree, to show the court, who I gather has not seen it, and the record that such an event took place, if I may.
You may.
And Mr. Harris, this is from last night's Dateline, and I personally taped it.
I take it there's no foundational objection. Thank you.
Hasn't located the spot. Perhaps that fact is sufficiently notorious so that it does not have to be played. The retraction, so to speak, by.
All right. Well, Mr. Bailey,
witness.
I just wanted to give you the opportunity.
I appreciate that, but I don't want to hold up the jury any more than we have. I'll simply make that assertion. I take it from lack of any contradiction that at least some members of the prosecution are familiar with the change in position by the witness.
All right. All right, Ms. Clark, anything else before we proceed with the jury? Is there anything else you wish to, any other comment on the record before we invite the jurors to join us?
I would only indicate, Your Honor, that in view of the more recent statement of Mr. Cordoba.
In view of the statement where Mr. Cordoba retracts everything he said to Dateline the night before, I fucked up and now I'm going to grovel in front of the court for a little bit because I made a fool of myself. That's where we're going with this. I just love that. And she was like, hey, she said he never did it. He never said that he denied knowing F. Lee Bailey. But now that he came out and said, well, yes, I remember it now. Now she's taking a little bit of a different tact here. A different tack, sorry. A tacket. She's taking a different tacket approach. No, she's taking a different tack than she did the day before. Now she's like, okay, well, now that he's changed his story, I guess I should stop being such an obstreperous bitch and maybe kind of apologize.
On the record before we invite the jurors to join us.
I would only indicate, Your Honor, that in view of the more recent statement of Mr. Cordoba, to which Mr. Bailey refers, and I'm familiar with it, the real issue is Mr. Cordoba's credibility. And I think we should turn our attention to that and get on with this in a professional manner.
All right. It would thrill me to death if counsel would apologize to each other for the rather
kiss and make up.
High level
the
of
court
betrayal
orders it.
yesterday.
Although I cannot say, Your Honor, that substantively speaking, the record, the evidence, and the information we had did not support the fundamental belief that we have a witness here who is not to be believed, who has no credibility. I
Ms.
do.
Clark, forgive me for interrupting you, but given the state of the record as we know it today, given the level of the comments yesterday, which were not appropriate, I think it would be appropriate to begin this session by both sides acknowledging.
She's like, I know you asked me to apologize, but let me talk about the witness here. The witness is not credible. It's not Mr. Bailey. It's the witness. The witness is a piece of garbage. The witness can't be trusted. The witness, and then he steps in and goes, now look, Marcia, I'm telling you, stop talking about the witness and apologize for saying inappropriate crap to F. Lee Bailey yesterday. He's calling her out here and saying, stop talking about the witness. I want you to apologize to Mr. Bailey for calling him a liar, threatening him with sanctions, demanding he be held in contempt, call him all kinds of names in court. You should apologize.
As we know it today, given the level of the comments yesterday, which were not appropriate, I think it would be appropriate to begin this session by both sides acknowledging going beyond the bounds of professional conduct. In the heat of battle, I understand, and that we all agree to conduct ourselves professionally today. And I only ask that of you first because you're standing and talking to me. I'm going to ask the same of Mr. Bailey as soon as I hear from you.
And I do.
Ha ha ha.
No, I'm serious. No, I'm sorry, Your Honor. I'm not going to be facetious. I do mean that. I really do. I don't like to engage in that sort of exchange. I think it is. I think it's unseemly. I think it's bad for the entire profession. And I do extend to Mr. Bailey my apology for the extreme nature of the exchange yesterday. I don't anticipate that happening again. And I think that we will all, from this day forward, conduct ourselves as professionals, seasoned professionals that we all are.
Thank you, Ms. Clark. Mr. Bailey?
I, without hesitation, apologize for what I have found as an unwarranted comment directed at Ms. Clark, and that was that her eyesight and memory were deficient. Very plainly, that was unfair since her eyesight is excellent and her memory is proven to be the same. My apology, most profound apology, is directed at the court. I've been doing this for 40 years. I was caught off guard with that accusation. The reaction was less restrained and certainly less professional than it should have been. And the thing that pains me the most is any criticism that has been directed at the court because of conduct of counsel, in my view, You're one of the finest trial judges I've ever had the privilege to appear before, and I think that criticism is unwarranted. And to the extent that I caused it, I do apologize.
Thank you, Counsel.
May I join in that, Your Honor? I was not even aware of criticism being leveled at the court. If that is the case, I really would like to take this opportunity to indicate that we, from the prosecution, do not share in that view at all. We send our most sincere apologies for any ill reaction that was caused by our conduct yesterday to the court. It was certainly unwarranted, unfair, and unjustified.
Well, Counsel, I appreciate that thought. However, that's why I get paid the big bucks. All right, let's proceed. Deputy Magnero, let's have the jurors.
So that the record is clear, the people do not intend to call Max Cordova. He is off our witness list as far as we're concerned.
Now, after all of this, they've decided they don't want to talk to Max Cordova because Max Cordova is going to say, yeah, Furman was dropping the N-bombs at the Marine recruiting station a few years ago. So they just said, never mind. We don't need him after all. Let's pretend none of this for the last 2 days happened. All right, the jury's going to be coming in here in just a second. And while the jury's out, we'll just read this one thing. Kyle Mitchell says, we'll accept Malort as a substitute so you don't have to chug quality whiskey. Oh, thank God Malort it doesn't exist in Korea. The yellow corn whiskey is probably about the closest trash they have to Malort. But no, that was kind of the thing. Is I started thinking and feeling guilty that the viewers are spending $100 or an aggregate of $100 for me to consume alcohol, and they're $100 and I'm drinking shit whiskey. So I decided to change and respect those $100 donations by drinking whiskey that is commensurate with the price level of
all right, Detective
super chats
Furman,
that people are sending.
Witness stand, please.
Yeah, Malort. Yeah, there is no Malort here, so great for that. So that's what I was saying. No, just get a cheap 120 proof absinthe. No. I've got absinthe up there. There's a couple of bottles of absinthe up there, real absinthe. See, that's the thing. You can't do high proof and $100 shots because you'll be dead. You have to try to find expensive whiskey as close as possible to the 40% bottom range. That keeps you going. But yeah, so that's it. As I said, you people are spending quality money throwing super chats at me, so I can only, in good faith, drink good quality whiskey. I just can't say, okay, the first $100 super chat, I can buy 4 bottles of yellow corn with that. So I can't just sit here and drink yellow corn whiskey all night on $100 shots. So that's why I said 25% of whatever from the fucking Friday streams I earn goes towards the next bottle. It's my respect to you for respecting me. That's all. That's all I have to say about that. Kyle Mitchell says terrible whiskey is better viewing value, but it's shorter viewing value. That's the problem. It's shorter value. Why no live stream on Rumble? Asks Tin Man. They steal less money. I still am working on getting Rumble to communicate with Korean banks and figuring out how to do the dual live stream things. The first problem is getting Rumble to communicate with Korean banks. I'm still working on it. It's really tricky because Korean bank financial regulation stuff is still pretty strict and pretty strong, which is why I don't do locals, because locals just does not do anything with Korean banks. So I'm doing my best. What I'm really working on is I have a PayPal set up for Korea, but it won't send to Korean banks. So I'm working on a way to set up PayPal to send to my US bank, which they take the least amount. So hopefully by next Friday, I'll have a designated PayPal set up that we can use so that nobody takes much of anything from your donations, which makes me happier because I get more out of it. And I also get to buy more expensive whiskeys. So that's short answer why I don't live stream on Rumble. It doesn't really work with Korea yet. I'm figuring it out, etc., etc. Let's get back to this.
Let the record reflect that the
Oh,
jury
I'll
has
pay
now
attention. Yes,
joined us,
I
all
live
of our
in Korea.
members.
I'm licensed for the
Detective
Utah
Furman
bar,
is
and I've
again
lived in
on the
Korea for
witness
34
stand
years.
under cross-examination by Mr. Bailey. Good morning, Detective Furman.
Good morning, Your Honor.
Detective, you're reminded you were still under oath. Mr. Bailey, you may conclude your cross-examination.
Detective Furman, do you recall that yesterday I indicated a certain area of the audience and asked you if you saw anyone there that you knew? Recall that?
Yes, sir.
And did you see anyone that you knew?
That I knew?
Yeah. Yesterday.
I know people, yes, in the audience.
No. Someone
Yesterday?
Someone that was connected with the preparation of your testimony.
No, I didn't recall, no.
Did you see anyone when you looked out yesterday, not here today, who was connected with the preparation of your testimony?
No, sir.
You did not?
No.
Do you know a Dr. Mark Goulston?
We take sidetracks occasionally.
It's a different name than I heard yesterday.
Bear with us,
Overruled.
shin dog.
Excuse me, counsel. Objections? Item 4. I heard a different name. Overruled.
I know a Mark. I don't recall a Mr. Goldstein.
Oh God, that would be so much
Goulston,
malort.
as I get it.
I still don't, sir.
And who is Mark?
I believe he is a doctor.
Psychiatrist, is he?
I'm not sure if he's a psychologist or a psychiatrist.
Okay. And under what circumstances have you seen him?
I've seen him in the DA's office.
Was he present during the grand jury session?
No, I don't recall him being there, no.
Has he talked with you at all about being a witness?
No.
You've never had any conversation?
Yes.
What have you talked about?
We didn't talk. He just said, you're doing a good job. Keep it up.
Did you talk to him before you testified?
No, not at all.
And he's had no conversation with you at all about the manner of your testimony, except some words of encouragement after the fact. Is that the way you leave it?
Yes, sir.
Did you recognize him when I pointed to him yesterday? Sitting next to Mr. McGinnis?
Assumes facts not in evidence.
Did you see me point yesterday in this direction?
I believe he pointed, yes, sir.
All right, indicating the back row of the seats reserved for counsel and the audience.
Mr. McGinnis is the landmark since he always sits there. I believe me, sitting next to Mr.
Nice
McGinnis.
chosen.
That's where I was pointing. Mr. McGinnis, Detective Furman had his hand up. He's the tall gentleman right in here.
Yes, sir.
Was Mark Goulston sitting there when I asked you the question?
Oral.
I did not notice him, no.
You didn't notice him. How
No.
many times have you seen this man, Detective Furman?
4 or 5 times.
Okay. Detective Furman, how did you call in the license plate of the vehicle that turned out to be Kalen's on the morning of the 3rd?
Okay, now this is some more important testimony. This also is going to him as a racist. F. Lee Bailey's trying to pin him down on not just the N-bomb, dropping N-bombs in the past 10 years. He's also trying to catch him using other racist terms.
Detective Furman, how did you call in the license plate of the vehicle that turned out to be Kalen's on the morning of the 13th?
Police radio?
Is that called a rover?
Yes, sir.
Is that something you carry on your belt?
No. You could, but in plain clothes, it's very difficult. So you usually just take it out of the car and hold it.
Okay. Did you have it with you that morning?
At different points I did, yes.
Right? Did you have it with you when you were in talking to Cato in his bungalow?
I don't believe so, no.
Did you have it with you when you went out to look for the source of the noise?
No.
Do you have any communications equipment with you at that time?
No.
All right, just waiting for F. Lee to get his notes together, make a few comments to his team, and then ask a few more questions. Yeah, wait, cops were racist in the 90s? Are they still asking for a friend? Yeah.
Is there a police radio code where certain words are used to indicate letters of the alphabet, as there is in aviation and the military, for instance?
Yes, sir.
What's the police word for N?
Nora,
V,
Victor,
N,
Nora,
H,
Henry.
I.
You put me on the spot.
Yeah.
Oh, it's Indio in the military. I'm having a Ida.
Okay. Does NVN have a meaning to you?
No, sir.
Do you use that on the radio at all?
No, sir.
I mean, the phonetic letters, Nora, etc.
Oh, the phonetics, if I'm running a license plate such as that?
No, no. You said V is represented by?
Victor?
All right. Do you ever use the term Nora, Victor, Nora when talking to the officers on the radio?
Why would I do that?
Do you ever use the term Nora, Victor, Nora talking to officers on the radio?
No, sir.
All right. Thank you. That's all I have.
Now, what he's getting at there was that apparently used to be a thing back in the 90s there in California. NVN was talking about black on black crime, N-word versus N-word. And that's how cops would communicate via their radio, talking about the various crimes. They'd be like, it's an NVN crime. So it's a well, what he was saying, Nora, Victor, Nora crime. So he was trying to get him on that. And I think he did with the, well, why would I do that? Why would I say that? Why for are you questioning me in such a manner, Mr. Bailey?
You're on until the other matters are settled.
Redirect.
Redirect time. Yeah. Yes, Nicole was white. It wasn't talking about that particular crime. He was just trying to get him to admit that when talking about black on black crime, he would use the radio code NVN. Not just specifically about the Nicole Simpson murder. Alfred Sparman says, man, I know that was black. That was back then. I'm sorry. I know that was back then and times were different, but that was hard to hear as a black man. Yeah, seriously. I mean, Mark Fuhrman is not a pretty picture. And the fact that he's the prosecution star witness creates some serious trouble for the prosecution. And I mean, that was the thing. I don't know what it's not like an it may be an Urban Dictionary, but that was a thing back in the day. Everybody knew like NVN was just, Nora Victor Nora was black on black crime, black on black call. It's a shitty situation, man.
Detective Furman, I'm going to direct your attention to your state of mind and knowledge at the time you stepped out the front door at Rockingham. That means, and by that I mean after you placed Cato Kalin at the bar and then walked out the front door to go out to the south pathway. At that time, sir, the first time you walked out to the south pathway at 360 North Rockingham, did you know the time of death for Ron Goldman and Nicole Brown?
No, ma'am.
Did you know whether Mr. Simpson had an alibi for the time of their murders?
No.
Did you know whether there were any eyewitnesses to their murders?
No.
Did you know whether anyone had heard voices or any sounds or any words spoken at the crime
Get away
scene
from her,
at the time
you
of their murders?
bitch.
No.
Great aliens blast there.
Did you know whether Cato
Nice
had
notes on
already
the phone.
gone up the south walkway before you got there?
No.
Did you know whether any fibers from the Bronco would be found on that glove that you ultimately found at Rockingham?
No.
And did you know the cause of death?
No.
I have nothing further.
See, and I think that was a bad redirect. I mean, I get what she was trying to convey, but in the minds of an average juror, she's just making him look like he doesn't know anything. Did you do this? I don't know. Did you do that? I don't know. Did you do this? I don't know. Did you do the other thing? I don't know. Instead of saying he had no knowledge of the events which you are trying to impute to him, it just makes him sound like, I don't know. She could have handled that so much better. She just makes him sound like he's dumb and doesn't know anything. It's unfortunate she didn't ask the questions in a more persuasive manner.
Mr. Bailey? All right, Detective Furman, I'm going to release you from further testimony today. However, you are still subject to recall. You are ordered not to discuss your testimony with anybody except your own attorney and the attorneys from both sides or their investigators. Do you understand the order, sir?
Yes, Your Honor.
All right, thank you very much. Your excuse, sir.
Thank you.
All right, ladies and germs, that is the end of 7 weeks of cross-examination of Mark Fuhrman by legendary attorney F. Lee Bailey. The reason I showed that was not to change your mind on what you think about the guilt or innocence of OJ Simpson. It was to show you give you a master class in cross-examination by F. Lee Bailey and show you how you can plant the seeds of reasonable doubt in the minds of jurors. And I hope you can see that. Whether or not the jury got it right is up to you to decide. But I hope that helps you a little bit more to see how the jury reached the conclusion that there was reasonable doubt sufficient to find him not guilty. When you get a prosecution witness who is a detective on the crime scene that lies about so many insignificant points, who doesn't follow his instructions, who wanders off all by himself without telling anybody, without inviting anybody to assist, without being instructed to do so, and finds the 2 most significant pieces of evidence linking OJ Simpson to the crime when not asked to do so and not directed to do so and not expected to do so, and then gets caught up in this whole obfuscation thing, can lead to a finding of not guilty due to reasonable doubt being put in your mind. I mean, it's a thing that F. Lee Bailey does. That's his job. That's his masterpiece. He's an excellent lawyer, one of the best defense lawyers you'll ever see in your entire life. Now, where do we go from here? Where we go from here is there's one more witness that F. Lee Bailey directs and Marcia Clark cross-examines. We'll do that next week. It's less than an hour. So we'll do that. And then we will go forward a few months to where the defense is putting on their witnesses, which are Kathleen Bell, who witnessed Mark Fuhrman say racist things in the presence of Mr. Cordoba that we were talking about a minute ago, and the screenwriter who has tapes of Mark Fuhrman dropping N-bombs left and right. And then there's we'll get into a few other things that Mark Fuhrman personally did, and then we should be done with this whole Mark Fuhrman series of questioning. So either next week or shortly into the following week, we'll be done with Mark Fuhrman, and we can turn our attention to master defense lawyer Barry Scheck, who is one of the founders and one of the principals at the Innocence Project, who just dismantles completely the LA County criminologist Dennis Fung. His cross-examination was 8.5 days on the stand, and it was brutal from the first minute to the last. And he was so disoriented and blasted by the time he got off the stand that the prosecution's star witness criminologist shook the hands of and hugged members of the defense team after he got off the stand. That's how badly he was thrashed. So that's where we're going to go next after we've just wrapped up with Mark Fuhrman here. Then we'll do a couple of other witnesses. We'll do closing testimonies, and then it will be time to find another trial. But that's still months ahead. So we'll see where it goes. And with that, our 2-hour stream has gone nearly 3 hours. So it's time to wrap it up. We've got a few more super chats and comments to get through here. I guess we have no more super chats. We got through all of the super chats. So thank you for those of you that did super chat. Right now we got just a few other comments that I found interesting and wanted to comment on. Patty Leather says OJ would never be convicted no matter what. That's a valid argument. There's a lot of people that say that it was a politically motivated thing. It was only a few years removed from Rodney King and the LA riots that resulted from the police being found not guilty with respect to the Rodney King beating. So this is a valid argument. Well, I mean, it's a validly made argument. Whether the argument itself is valid or not, I don't know. But it was something that was talked about, discussed, and argued at that point in time, that it was sort of some sort of vindication for the Rodney King incident. But again, what I'm doing here is not to change your mind on whether guilty or not, but just to show you how reasonable doubt can be cultivated by master lawyers. Mike Fenn says F. Lee Bailey was required viewing when I took mass comm law in high school. Amazing lawyer. Yeah, and we'll get into a couple of his interviews after we get done with F. Lee Bailey. We'll watch a couple of his interviews that he did early on in his life and later on in his life, just to give you some insight into who he was and his impact on the legal scope, the scope of the the law sphere, right, or whatever the hell you want to call it. And Fedorovsky said, I just bought a couple of bottles yesterday, Oban 14 and Glenmorangie, the Quinta Ruban 14. Yeah, the new the Quinta Ruban used to be 12-year-old, but a year or two ago they changed to a 14-year-old. It's a great whiskey. Glenmorangie holds a special place in my heart as being one of the whiskeys. It was the Glenmorangie La Santa that really opened my eyes to the potential of whiskey. So Glenmorangie has a special place in my heart, and right there is an entire shelf of eight or nine different Glenmorangie scotches. Oban 14 is a solid baseline scotch that it's one of the benchmarks of scotch. You cannot go wrong with either of those, Fedorovsky. So congratulations on those purchases. And with that, if there are no more super chats to read through, if there's nothing else to get through, I think that brings us to the end of another Thursday edition of Legal Vices, the OJ Simpson trials. like I said, it's not the most popular, it's not the most lucrative from the grifting standpoint of the streams that I do, but it's kind of important. It's important in the history for the history of law, for the understanding of uh, trial techniques and arguments. So that's why we do this. As we wrap up here on the U.S. Thanksgiving morning, I guess it is. Thank you all of you mods that are here. Thank you for your time. Thank you for donating your efforts, your sleep, your personal time to helping me out here and to making this show what it is. Thank you to everybody in chat for all of your viewpoints. I love how the Vice Squad is hands down, as I said, the best chat on the entire internet. I love the fact that we can disagree with each other. We can have altering viewpoints. We can have alternate viewpoints. We can have divergent views, but we still keep it mostly respectful to each other. We can share our thoughts, share our arguments, share our viewpoints with each other, and we still respect and love each other. That's what, I mean, you guys are great. The chat is awesome. Mods chat, thank you so much. And again, for those of you that are just listening to this in the background as you go about your day, working in the office, taking care of kids, driving around, running your errands, whatever it is you do, thank you so much for having us on in the background. You're an integral part of this program too. I just want to know that I'm thankful for your presence. I'm thankful for you being here. And I would appreciate it if you would just find some time in your day to pop on over, give us a like, make a comment or two. Let us know you're thinking about us. And for those of you that have given super chats today, thank you for that. That is always appreciated, never expected, never required, but always appreciated from the bottom of my heart. Thank you for those. And that brings us to the end of today's show. On your way out, if you haven't already done so, please hit that like button. Subscribe if you're inclined to do so. Leave a comment. We've got some merch links down there. We're going to be getting some law racks, hoodies, and sweaters worked out over the next week or two. And we'll see you tomorrow. See you tomorrow for day 2 of the Courtney Clenny bond hearing. Will the judge let her out on bond? That's something we'll have to wait for. Next Monday, Maritime Monday. Next Tuesday, we're going to be getting a Taylorship business update and the latest on the Idaho murders at the University of Idaho. Next Wednesday, I forgot what I said I was going to do next. Next Wednesday will be the Colorado incident. And then next Thursday, we'll be back to OJ Simpson. And game over, says Xcomer. Thank you so much for the last super sticker of the day. You rock. Everybody, we will see you here tomorrow at 8 a.m. Eastern Time, at 1 p.m. London Time, 10 p.m. Korea, and midnight Canberra Time for the Courtney Clenny bond hearing is what it's called. Day 2. Love you all. See you tomorrow. And until then, make sure you do your best to enjoy your legal vices. I'm out. Peace.